Please call the list. Today is not the mentioning date.
What happened is here the petition has been to participation and 55 is a listing. Pursuant to the order passed by the Honorable Supreme Court, it has been made by the Lordship as well as by the Honorable Division Bench. The plaintiff will not be allowed to
Mention on Monday. Sorry, it's not an adjournment. Yes, you mentioned yesterday. Yes.
Yes, my lord. This is the schedule, my lord. It's about to start from tomorrow morning.
Let me see.
The round is about to start from tomorrow.
The fee payment date tomorrow is there.
My lord.
Fee payment date.
My lord, it's about to start from tomorrow, my lord.
Yes, you pay fee. What is the difficulty?
Rank is changed, my lord. Against my rank, my lord. My rank has been changed, my lord. Now, against which rank I will pay? That is the problem, my lord. I have to select the colleges as well, my lord. If it is not being taken up, my lord, I cannot select the colleges as well.
Why your rank has been changed?
My lord, we have no information about that. All of a sudden on 15th August, my rank has been changed. I have annexed everything.
Tomorrow, urgent motion.
Lordship, yesterday I mentioned.
Please don't mention any other matter today. Call the list. Sorry.
Item number 1.
My lord, I am for the response number 3. May I be permitted to file the report in the form of affidavit?
Why matter has come under the heading
Yes,
to be
sir.
mentioned?
Matter is one matter. I have this is my transfer made matter after receiving that. The matter has come to this petitioner is this junior assistant engineer, field assistant engineer.
Group 6 matter.
Group 6 matter. That should be released. For this reason, I have mentioned before your lordship.
You have stated in the presentation from group 2, other education.
This is a group 2 service matter, my lord.
Transfer
Group 2.
Group 2 service matter. This is a group 2 service matter. Poshchimbango Samagro Shiksha Mission. Therefore, it's a group 2 service matter.
But he is saying that in the post of assistant engineer.
field engineer.
No, True, but they are working under Poshchimbango Samagro Shiksha Mission.
Assistant engineer, he is saying petitioner very. Take back your report. Matter has come up in the list.
To correct this.
Matter has come up in the list under the heading to be mentioned on being mentioned by the learned advocate representing the petitioner. Stop. Next paragraph. Learned advocate for the petitioner submits that the issue involved in this writ petition relates to group 6 of classification list of different types of writ proceedings. Stop. Respondents are represented by learned advocates. Next paragraph. Writ petition stands released due to want of determination and be placed before the stands released due to want of determination and be placed before the bench having determination. Next paragraph. Leave is granted to the learned advocate for the petitioner to amend the presentation form and pro forma page of the writ petition.
Grateful.
Amendment টা করিনি। Amendment টা করে নেবেন। Item number 2.
Correction matter the bottom line matter the husband matter on the date of husband matter instead of matter chart forms.
It's like which correction you require? Date of husband.
Yes.
For the schedule.
Any. দিয়ে দিয়েছে।
Order dated 13th August 2025 requires correction. Stop. Inadvertently, in the last line of the first page under paragraph 4 of the order dated 13th August 2025, it was transcribed as retirement of the petitioner. Instead of retirement of the petitioner, quote unquote, instead of date, instead of date of, instead of quotation should one within quotation, instead of date of husband, quote unquote. On education. Date of the ঠিক আছে, retirement of the petitioner, এই retirement of বললাম তো এই জায়গাটা retirement of এর জায়গায় following the date of husband, death of husband, then of the petitioner, following the date of husband, following the date of the আছে date of, then date of husband of the petitioner, date of husband. Next paragraph, department is directed to incorporate necessary corrections in the order dated 13th August 2025. Next paragraph, this order forms part of the order dated 13th August 2025. Next,
Item 3.
Madrasa Shiksha Kendra law. Paid for release.
Land advocate issue. Land advocate representing the petitioner submits that the issue involved in this writ petition relates to madrasa education. Why it has not been indicated in the presentation form at the time of filing? Writ petition stands released due to want of determination and be placed before the bench having determination. Next paragraph, leave is granted to the learned advocate for the petitioner to amend the cause title, now to amend the presentation form next.
Item number
Yes.
This is a report, my lord. It has been allowed.
19 June report, why it was not placed before this court on last occasion?
After the matter was called on, then my learned friend received
The report was directed to be filed by 3 weeks from the date of passing order on 6 March.
Yes.
Subsequently, matter was taken up on 9 June. And this 19 June, and then their matter was taken up on 14th August. Then also 19 June report was not placed.
It was not sent to us. I am told that it was sent
This is
subsequently.
not a report.
No, it is written.
This is nothing.
All the medical
This is
reports
a,
are given.
this is a, it is a communication to the state advocate.
No, kindly
Is
please
it a
say that-
report?
No, not in the,
Is it a report?
not a perfect form.
Then
It has been, the medical documents have been.
I want a report, formal report from the DI. Is it a report?
No, it does not look like a report, my lord. I candidly submit, my lord. It has come to us on the heading report, and the last line it has been given.
Don't be too clever before this
No,
court,
I
Mr.
am saying
Lairi.
whatever I have received, I am handing over, my
You are before a wrong court in that event.
No intention, my lord.
Is it a report?
No, my lord. It is not a report. It is not acceptable to be report, my lord. But that is what we received, my lord. That I place before your lordship. And it has
A
been.
formal communication to the learned advocate for the
I
state.
understand.
And you are trying to project it as report.
It is written as report. It is not like a report, my lord. I am submitting before your lordship. It is not like a report, not in the formal way we understand as report. It is not, my lord.
And that has to be after 14th August 2025.
Yes, my lord. That the last occasion lordship extended
And
the
this is
time.
19 June 2025
Yes.
communication to the learned advocate
Yes,
for the
my lord.
state.
Your lordship extended time on the last occasion for us to submit the report.
Where is the report?
This is what we have received, my lord. We received it on that day itself later on. When the matter was called on, then the matter, my learned friend received the report. Right? Yeah, yeah. Right. Acha, acha.
When petitioner was medically tested?
My lord, it was on 17th of June. Medical opinion was given 17th June. On 18th June, it was forwarded to DI by the CMOH, and 19th June, this report was prepared. এটা পরে পেয়েছো তো ওইদিনকেই শেষ দিন
Give me that document.
Second page is the communication, my lord. If your lordship kindly takes the second page, that is the communication, and the CMOH has sent it to the DI at page number 2.
Issue. In terms of the order dated 6 March 2025 and subsequent order dated 14th August 2025, District Institute of Schools AC Hooghly being respondent number 4 is required to file a formal report. disclosing medical report on medical examination of the petitioner by Chief Medical Officer of Health. Stop. Next paragraph. Today, one memo dated 19 June 2025 is filed before this court, which was addressed to the learned advocate for the state respondents. And the same is not in the form of report which needs to be filed as per the order dated 6 March 2025. Stop. Next paragraph. Respondent number 4 is directed to file a formal report strictly in terms of the order dated 6 March 2025 on the next date, failing which appropriate orders shall be passed. Stop. List the matter under the same heading on September 2025. Next paragraph. Memo dated 19 June 2025 is taken on record.
My lord, can I take back the original copy and give the, because I.
No, this will be with
Very
the
very
court. Next.
Item number 5.
Petition.
My lord, I appear for the respondent university. I am led by Mr. Shomo Mojumdar. My lord, only my lord requesting if this matter could be taken up tomorrow, my lord.
But on in view of urgency, it is not
Emergency.
What is the urgency?
Day. And did not open the. These persons are allegedly accused of ragging proceedings. Not they were boarders in the hostel. Now, an unfortunate incident did take place, my lord, on the 9th of August 2024, which prompted, my lord, initiation of proceeding 9th of August 2023, and my lord, which prompted initiation of proceedings under the ragging regulations, etc. Ultimately, my lord, it culminated into a show cause of 30th of July 2024. My lord, assailing the show cause, these 3 petitioners along with others came to your lordship's court, my lord. The matter was extensively heard. And, my lord, the bench, my lord, presiding over the bench, my lord, the Honorable Judge, my lord, granted us some interim protection to the extent that they shall not proceed further with the show. Now, my lord, we were permitted to continue. The nature of punishment in these 3 petitioners' cases, my lord, 1 year, 1 semester rustication and debarment from hostel. Now, my lord, that apparently was not given any effect to. These persons will not have pursued their studies in their respective courses in the graduation. Now, what they have done, rather through what they have done, they have not published their results for the semester results. 5th and 6th semester results are awaiting. In the meantime, an admission notification has been published, in-house admission, internal admission for Jadavpur University students.
In the next semester.
In MSc. Post-graduation, MA and MS. That notice.
The graduation level, what are the number of semesters?
6.
The result of which semester has not been published? 5th and 6th.
But ultimately, what is happening is, since the results are awaited, since the results are not with us, we cannot proceed further without taking of admissions. The last date, the date for publication was 12th of August. The last date was apparently 22nd. That is
for publication of result.
No, for admission.
12th August.
22nd. Date
it is over.
We have filed it. We have taken leave. We have filed the matter before. Not on the 22nd, for whatever reason, the business did not commit. That is, of course, the client, they were there. They appeared before the Honorable Judge. Because the other side was not there, the matter could not be taken on the 22nd. Thereafter, it was brought to your lordship's gracious consideration yesterday, and the matter is appearing today. I am only requesting this. The admission process is on.
How long this admission process will continue?
Last date is 22nd.
Yes, how long this will continue?
My lord, only my lord kindly takes the matter tomorrow, my lord. My lord,
You are
I-
not aware of this.
No, my lord.
Yes, how long it will continue?
That they are filling up the seats. If he is in, if my senior is in difficulty, Milord, let it be taken up today at any time, subject to his convenience.
Are you aware of what is the last date of taking admission?
22nd. In terms of the notice, 22nd.
So then it is over.
It is not over. Milord, since we moved court, since we have brought it to the court's notice, and since the matter, the principal matter is also pending before the Honorable a coordinate bench of your Lordship's court. Milord, it is just awaiting final hearing. Milord, I was humbly beseeching your Lordship that without prejudice to.
But the matter which is pending there, this
There the-
application of result is not an issue.
No.
Yes, one application has been filed, my lord, by one of the
Application of
petitioners.
result.
Yes.
What
And
application of-
three other petitioners of that matter has filed subsequent writ petition, which is, my lord, before your lordship.
Milord, my
How many persons are involved were found? 15.
15 persons
the writ
in that
petition,
particular
Milord,
writ
that has been
petition.
carried to your Lordship's court.
My lord, they had challenged the show cause notice at an interim stage. They did not reply to the show cause notice. And subject to correction, my lord, the interim order which was granted was extending the time period to reply. Thereafter, my lord,
No,
there
no.
was
Perhaps she is not correct.
Yes, yes, continue.
thereafter, my lord, there was another order which was passed by my lord Honorable Justice Joy Sengupta, my lord, enabling the petitioners to attend the classes, for which they were attending the classes, they gave the examinations. My lord, it is really in the nature of modification of that particular order. My lord, I have that order with me, but my lord, my lord, all the instructions which are required, my lord, are with Mr.
Where is
Modi.
Mr. Modi?
My lord, he's on his legs before court 30.
We will tomorrow, not today. Ish. Matter is heard in presence of the learned advocates representing the petitioners and Jadavpur University
Lordship.
being the contesting respondents. Stop. Whether the state is represented,
The state is not.
Not there.
UGC is apart.
stop. Learned accommodation is paid for on behalf of Jadavpur University. Stop. List the matter under the same heading tomorrow, 27th August 2025 for further consideration. Opore the every service filed on behalf of the petitioner is taken as a. Next matter. Come back.
Anytime during the day. Also,
Come back tomorrow. Do you have any difficulty tomorrow?
no, no, no. Difficulty is not the, this, every day is, we are losing. They are going to take a
No.
point.
Come back, come.
Item number 6.
Yes.
Since local arrangement was not done, petitioner filed a writ petition. Honorable division bench directed for fixed application. It was reached in impugned order has been passed 87. Other day, it was my junior's fault not to impede the chair secretary. It has been and service has been affected, subject to correction.
Yes.
So, in terms of the honorable division bench, it was this after arrangement of the some teacher from the another school. DI has forwarded this in the contempt proceeding. It was done. It was reached before the
Where is the illegality in this order?
illegality so far
887.
as first person is lordship other desired than lower PTR. I may not be accommodated, but in the other two schools there should be another option to be given for my choice. That is the. And if your lordship kindly sees, I have that.
But you have applied, you didn't, you applied 3 schools.
But in the subsequent proceedings after 2000, but there is no 3 school. There may be another accommodation can be done.
Under
Since
what
I have-
provision?
Subject to correction. Similar issue was decided by honorable division bench.
I have also decided.
No, but in that in terms of the 2015 rules and amendment to that extent also, the honorable Supreme Court, since the lower PTR and other things are there, another option I am entitled. The honorable Supreme Court in the SSC case referred to the SLP, it has been clarified by the honorable Supreme Court. I have that option.
No, question is, you are trying to rely upon the amendment.
Yes,
Show me the amendment.
at page. This is the amendment of page 41. And page 43, after reaching, after 3rd January notification, local arrangement, it can be. There is cryptic order, it has not been mentioned in which school other candidates chosen within the time frame. That has
Page
not,
41.
page 41, the new rule amendment.
Each page having 3 pagination, 3 page marks. Number.
It my page,
Very
page-
confusing.
this 41, it starts to partitioning.
Yes, page 41, which
Yes,
part?
43, page 43 from the top, column number 4. After sending the application from the DI, what the commission are to
Where,
do?
where? Page 43.
Page 43 from the central commission, upon receipt of the application or transfer from the district inspector.
Yes, district shall consider the
Shall
same.
only against in vacancy available to the commission consideration in the following on the following basis. Now, there are some guidelines has been framed. Now with time frame, there is time frame on page 49. When commission,
Number of preferred schools was not confined to 3 schools.
yes,
Where is that provision?
subject to correction, my lord.
Yes,
In
Mr.
case-
Rai, where is that provision?
My lord,
October 2021.
it is not, my lord. It is not.
It is not means?
My lord, it is not incorporated in this, my lord, judgment, in this rule, my lord. My lord, confinement of 3 school is not in this rule, my lord.
Not an issue.
Not in this rule
So
amendment.
here it is an issue, confinement.
Here
of
it
3
is an
schools.
issue, my lord.
So
If
why
you
you are
notice
relying
kindly,
on?
Now,
Because your position is this: if you are not fitted against or transferred to one of the 3 preferred schools, then your application should be considered in connection with other schools. Other schools.
Now, if you
Where
look
is that?
kindly-
Where is that provision?
there is
There is an
no-
amendment.
Yes.
Show me that amendment.
But there is no provision in respect of 3 schools.
Yes, previously there was a provision for
Initially,
3
unamended.
schools.
Here
In
is no.
2015 rules, there was a provision
Correct.
only to give preference, which should be confined to 3
3
schools.
schools.
Subsequently, these 3 schools was omitted, and it can be more than 3 schools,
than-
as many schools as one can indicate.
Obliged.
Now, where is that amendment?
But
That is what I'm asking you.
that entire group, rule 6 and 7 has been substituted by this amendment
my lord,
without manner.
Where is that
Now-
amendment?
kindly D, my lord. 6(4)D.
In 8 September
September.
2021.
8
yes.
Sep- 6(4)(d). In case of an application for
Transport D.
in case of an application for transfer in the category of rule 4A to D by a teacher of a particular subject to a school which has already having sufficient or excess teacher in that subject, the Central Commission shall not consider the application for transfer to the opted school. In that event, when all option exercised are not found suitable, the incumbent may be considered for transfer to other school having requirement of subject teacher to the nearby opted school. But this provision is only applicable when application is made in medical ground, in the ground of physical disablement and divorce ground, my lord. 4A to D, my lord. It is not available in 4E, my lord. Application in 4E, my lord.
In case of applications for transfer. That's why rule 4A to rule 4D.
D. And now, my lord, kindly turn.
Just a minute. Single vacancy.
That is for 4A to D. Now your submission is that application for transfer was made under 4E.
4E, my lord.
Now what he is trying to submit, that previously it was confined to three schools. Subsequently, there was an amendment. Where is such amendment?
My lord, there is no amendment. Only judgment of the Honorable Division Bench of this High Court. And your lordships, considering the judgment passed by the Honorable Division Bench, also considered the issue, my lord.
No, but there was no amendment that more than three schools can be
No,
considered. It was not confined.
It is initially 3. Entire rule has been substituted by these rules. And my lord, if you also kindly see,
But if your application is under 4E, how this 4A to D
4E that
amended
next,
amended 6(4)D will apply?
not D, E. Application submitted against the single vacancy is more than one reasons
Yes.
will be considered, and other preference on the ground of 4A to E. Now it is to be counted in terms of column number, my lord, marks 4I. If
Just a minute.
my lord, sorry, right hander up. সবগুলো মিলে সব মিলবে করতে হবে। এটা রিজেক্ট করেছি ওই গ্রাউন্ডে, মেডিকেল গ্রাউন্ডে
আগে আছে।
Yes.
Now, if application submitted against a single vacancy with more than one reasons
Yes.
will be considered in order of preference from the grounds mentioned under 4A to E. Now, your application was not for a single vacancy.
No.
So
They
how
are-
this
they are
4E
mentioning
will be
I-
placed into service?
Yes, grateful. My lord, kindly come to then EI. How the marks to be allotted in respect of every grounds. Now they are saying in the impugned order, column number, kindly see in parity with the impugned order. In parity with the my lord, this I along with the impugned order. They have not discussed anything, no reasoning. How they have made
No,
the
they have given
No,
the
no, no, no.
reasons.
My lord, how can you see?
Yes, yes.
It appears from the Utsosi portal, there exists multiple application pending, including medical ground.
Yes.
In both other two preferred school, one gone for your lordship lower PTR. If your lordship does not permit this. Now, both other two preferred schools, since you have applied it any other grounds and which is lower in priority, how the lower is that is not discussed.
Your application is not on medical ground. Your application was on other grounds.
My lord.
So therefore, it is not under 4A.
A to D.
4A to the medical ground is 4A.
4A.
4A. Your application was not under 4A. It was under 4E. Now, if medical applications are, if transfer applications on medical ground is pending, then you will not get preference. That is what it is stated.
They have not disclosed how.
What
now,
disclosure?
Marks, how marks to be allotted?
It's not required. Once
Because-
medical application is pending, you are out.
I am
So
giving
therefore,
an-
no
one-
disclosure of marks is required.
No, no.
Try to appreciate. There is no apparent flaw in the
Lower
order.
priority.
Order may not be very descriptive, but it is specifically stated that it also appears from the Utsochi
Yes,
portal.
Your Lordship, kindly read.
There exists multiple applications pending, including under medical ground in both
They
the
are clubbing.
other two preferred schools.
My lord.
Now, since you have applied under any other ground, which is lower in priority,
In
your
potential rank.
potential rank is lower than such medical ground applications.
That
If
lower
medical
rank,
ground
how it
applications
has
are
been
there,
calculated, it has not been
it's not
disclosed.
required. Once medical applications transfer on medical ground are there, once transfer applications on medical grounds are present, you are out. So there, yes, further elaboration was required. When there are two applications, there is, suppose there are no other applications for transfer on medical ground. There are confronting applications or applications by more than one candidates. All are seeking applications under 4E. That is on the ground of distance. Then further elaboration was required. But once a medical application is there, which is to be adjudged along with the application under 4E, then you have no case.
Subject to correction, if your lordship, then kindly come to 49. There is a time frame within which entire application to be done. 41 days total from the.
I was under the impression that you are taking a point that there was an amendment that it is not confined to 3 schools.
No, any schools. Not no.
So
not
your applications is on the ground of distance.
distance. Now,
So if it is a distance grounds application and against distance ground application, medical applications are pending, then your applications cannot be considered.
cannot be. I am interpreting. Now, kindly give me 1 month time. Page 49. There is a time schedule from the school authority to the Malad SSC. Enter 2 weeks, 2 weeks, then 3 weeks, then 2 days. Then 42 days I have calculated, 41, 42 days. My application reached to the commission by 42 days.
When you have applied,
Not, after the order passed by the
Page,
Honorable Court.
page 73.
Yes, it is there.
date.
Dated, my lord, 4th of September 2024. It is an offline application, my lord. So, my lord, the point of
Is
confinement
it in
of
the prescribed format?
no, my lord.
Then
But, my lord, pursuant to the direction of the division bench and subsequently in contempt, my lord, contempt court, my lord, given liberty to the petitioner to approach the read court, my lord.
No, to the authorities.
My lord,
On that basis, it was
on the self, my lord,
performed
if your
and was-
last page of this writ petition, page 90, page 89, from page 89. It is clear from the aforesaid observation that the statutory authorities are required to take into consideration the notification dated 3rd January 2022 and decide the matter without being influenced by the observation made in the order. Consequent thereon, the West Bengal Central School Service Commission has passed the following order on 4th March 2020.
where from you are reading?
My lord,
Only contempt
page
disposal.
in disposal
After
of the
order
contempt.
passed by this order, contempt was disposed of since separate order.
For
was
my lord,
passed, so you
Where is the order passed by this court?
yes, my lord, it is in the
yes, initial division bench. order.
page 70. Page 70. Operative part, page 72. Prescribe for me application code.
So this is the order passed in this on the application of the petitioner, passed by the Honorable Division Bench on 29th August 2024.
Yes, ma'am.
Thereafter, what happened?
Page 73, the application made before the school authorities.
Then it was processed and reached commission. Commission has taken a decision. Where is the why contempt proceeding was initiated?
Because of the fact that in spite of the Honorable Division Bench judgment, DI did not take any step regarding local arrangement in terms of that notification of 3rd January. The 3rd January notification, contempt file before the Honorable Division Bench. But in the on contempt proceedings, DI found that the suitable candidate is there and forwarded the case of the petitioner to the commission. For
Contempt
taking
before the
further
division
decision.
bench.
Before the division bench. And on that
But
process
before
of
the division bench, there was no specific direction upon the DI to find out the teacher.
there was a direction that to follow the 3rd January notification. Therefore, the DI took the endeavor to found out the local arrangement and thereafter send it to the commission. The commission passed the order and there is lower rank, potential rank has not been discussed how it has been reached in conclusion that I am the lower rank. There must be a specific reasoning for giving
Is
protection.
it required when authority
Because
is
of the fact,
considering
suppose I am giving one
considering on distance ground against a medical ground application?
but that has not been bifurcated in any manner in that.
Yes, yes, it is there.
It is there only which is lower priority. You
Particular and marking.
but yes, mark how that come the authority came to the finding in a lower rank. There must be. And one give example.
Where is the provision regarding marking of
Yes.
application for transfer on medical ground and application for
No,
transfer
my lord.
on the ground of
There is no my lord, provisions. My lord, if your lordships kindly turns to page 43, I, 4I. Only provision is made when an application
just a minute.
Yes. 4E.
Oh, against a single vacancy, if more than one application under 4E,
E, any other ground.
then how it is to be, how marks are to be allotted, and which application is to be given preference.
Preference. But on last occasion, it is fallen from your lordship, my lord. It is in rarest of rare cases, my lord, where my lord alternative arrangement has been made, my lord. My lord, your lordships, my lord,
No, but that part is over so far this matter is concerned.
yes.
Already DI has provided a alternative arrangement in the school of the petitioner, and application of the petitioner has reached commission.
Commission.
Then commission has considered it.
Consider.
While considering, commission could not allow transfer, that is under check.
That is
So therefore, the alternative arrangement in terms of providing or deputing a teacher in the school of the petitioner is not
It's
an
not
issue
an issue.
before me today.
Yes.
Because that the hurdle petitioner has
Over.
crossed.
Over.
Now today court is considering the validity of the order dated 4th March 2025.
Looks odd.
বোঝাই যায় না। অস্বীকৃতি।
Yes, sir.
Yes, any other decisions you are trying to
Yes,
rely
my lord,
on?
I'm trying if in respect of those
First, you answered the point that if there is an confrontation in between an application made on the ground of distance, as you have made an application for transfer, and on medical application for transfer on medical ground, then how your application would be given preference? Tell me.
my I'm giving one example, thereafter I'm answering to your lordship's query.
No, example is not
No,
required.
example.
Only where is the provision
Yes.
to give preference to
But
your
if your
application,
lordship, my
ignoring the
application-
application on medical grounds.
My application initially was rejected by the authority. I'm trying to by the single teacher ground. There is no single teacher. 3rd January came into force. Honorable Division Bench said you make a local arrangement, proceed the further. If your lordship see page 53, in respect of that single teacher ground subsequent 3rd January. In consonance to the initial amendment, September 8.
53 years.
Yes, the DI will, my lord got it.
Yes.
Communicate such an arrangement to the school concerned and HOI in question and forwarded the application to the DSC. Not done. The DI will then forward the case to the WBCSC for consideration. WBCSC will suitably recommend if there are no other post which is blocked by the medical ground, suitability to recommend in case of transfer to the WBSB. Therefore, my case suitability to be accommodated. Subject to correction or interpretation of law. And board will issue transfer order accordingly.
Yes, West Bengal Central School Service Commission will suitably recommend the case of the transfer to the West Bengal Board of Secondary Education, and board will issue transfer order accordingly. Does it mean that if you have applied against a post and against the same post another medical application is pending, application for transfer on medical ground is pending, then your application will be given preference?
No, I am not saying
It
so.
is, that's
in
why the
particular
word
schools
that's why terminology is used suitably.
suitably. If those posts,
If you are found
Well-
suitable, considering the pendency of the applications against the post, then you will be recommended.
Grateful. Now,
But if you are not found suitable in view of existence of other applications for transfer on medical ground, then how your application will be given preference?
To be-
Because at the end of the day, your application is on the ground of distance.
Well, there is some bifurcation preference to be given to the medical. Now,
If that is not incommensurate with my feasibility, then subsequent option for accommodation in the nearby school or something else option to be given. That is my contention.
Under what provision?
There is a provision to that effect of WB SSC will suitably recommend. That is the I am interpreting. If you I am giving the judgment of Supreme Court. If
It is what judgment?
yes, in accommodation, in respect of the further option, in respect of if there is other post, if the post is mean either lower rank or medically or in blocked by medical ground by another authorities. You will also kindly see.
But in this, with regards to this judgment, my
Record
lord,
my submission.
that this is not applicable in the present case, my lord. In this matter, my lord, the applicant made an application under the portal. There are three choices. So, my lord, the contention of the writ petitioner in that writ petition as well as appellant, that we are being restricted by the portal to opt for only 3 schools. Well, here in the present case, my lord, the honorable pursuant to the direction of the honorable division bench, petitioner made this offline application. She can make not 3, my lord, 30 schools as his preferred school, my lord. Without doing so, my lord, only preferring 3 school, now, my lord, they cannot take this point that I am being restricted by the School Service Commission only 3 schools, my lord.
I cannot know because of the online blocking. Where is the vacancies are? In the online blocking, there are my lord vacancies. It is
Yes, which judgment you are relying?
the commission preferred an appeal before the Honorable Supreme Court. Supreme Court will interpret it in the fashion.
The division bench order.
Yes. So that division bench will carried to the Honorable Apex Court. And Apex Court will
Just a
modify.
minute.
Considering Rule 6, আমাদের একটা Rule 6 amendment. ছিল এটা 6 এসছে।
Supreme Court has not said hasn't said anything.
No, so option to be given.
Not a
in respect-
judgment of the Supreme Court. Supreme Court has affirmed the order of the division bench that one more option can be given.
Yes, in
Where?
of the amendment.
Where? That is why I was asking you at the outset that that application for transfer can be made, which was initially restricted to 3 schools. Now it has not been restricted to 3 schools.
So I leave it to
Mr. Ghosh Chaudhary, where is that amendment? I had the occasion to consider the Supreme Court order.
There is no specification. There is, it has been repealed or modified to that it's a framework notification. But in 2015 rule, there is a restriction that the candidate must be confined in
3 schools.
silent.
Silent on this. Silent.
So there are in this silent that division means that a candidate may otherwise eligible. DI board that is otherwise eligible after.
So you could have indicated that in your application.
Regarding
Why you have not indicated it?
vacancies.
Yes,
Vacancy was.
I could understand that it was not, your application was before that. When you have applied for transfer,
Initial.
no, in terms
Subsequent.
of the order of the
24,
Honorable Division
24.
Bench,
Page, yes.
page
73.
73,
Yes,
you could have applied for as many schools as possible. You didn't do this. Now you are asking the commission to find out a school for you.
I could not get any option for the vacancies because of the offline.
Yes, sir. In the writ petition, secretary, the order dated, memo dated 4th March 2025, issued by the Secretary, West Bengal Central School Service Commission has been captured. Since in the said memo dated 4th March 2025, respondent number 13 could not transfer the petitioner to one of the three schools preferred in the transfer application. So, you opted for three schools?
Initially,
No, in page 73.
in preventive, I did not give any option. Because of the suitable vacancy I wanted from the College Service Commission, the
Service Commission.
School Service Commission, I
Oh,
did
in
not give.
page 73, you did not.
No option was made.
Matlab, page
They have
74, if your lordship kindly turns to page 74, include.
Include.
Matlab, this is an application with prescribed performer. Application.
Maybe.
There
Yes.
must be an application.
Any of
And
the
he prefers for three schools.
Three
I dispute.
Otherwise, how School Service Commission suo moto can take action and say this kind of.
Because of my earlier three schools I chosen, in those schools they have considered, not subsequent. D. Confirm to this.
Then where is the question of three schools comes in?
Since they have considered initially when I made an application in the year 2021, they have considered.
Where you have stated that you should be accommodated to any school in your application at page 73. Show me.
Page 73,
Page 73, show me that where you have stated that you should be accommodated to any school on transfer.
There is no mentioning. Paragraph, last paragraph. On the above facts, circumstances, the applicants humbly praying for consider the above pair for transfer on special ground as a fit case for transfer from the present school of that, and that on the above
For
circumstances.
transfer from the present school of nearest school.
Nearest school.
Permanent. It doesn't make any sense.
No. Present
Present
school of the
of
present.
nearest school of permanent resident of the applicant in view of the, what does it mean? And previous application was enclosed. Enclosed application.
Matlab, kindly turns to page 77 once. Order of the Honorable Division Bench, operating part.
Fresh application.
Yes.
We therefore permit the writ petitioner appellant to make a fresh application seeking transfer to the competent authority within a week from the date of self-same ground or any other ground if available. On the receipt of the said application, the authority shall complete the exercise as requested under statutory provision, and observing shall take note that notification of 3rd January 2022 within 4 weeks such and such. So, therefore, they, in pursuant to the direction passed by the Honorable Division Bench, they have not applied, make any fresh application before the commission till today.
Neither.
No, that is the application.
Fresh application,
Page 73.
applications including every credentials, my lord. It is not that an application in as a representation is to be directed to be considered.
There are two orders by the division bench.
No,
One is
an-
PRC,
Same.
contempt proceeding.
Con- Justice sends judgment division bench in a contempt proceedings and initial judgment of Justice Standards division.
So you made application in terms of 29th August 2024, which is at page 73.
Obliged.
But you have not indicated that any schools you
No, any
can.
school I have not mentioned. I have not mentioned any school.
হ্যাঁ, কি বলছিলাম?
My lord, kindly, may I, my lord, clarify. My lord, kindly turns to page 59. This is the original application and the school
In the
opted.
original application on the portal, she applied against 3 schools.
3 schools.
To that extent, he is not disputing it. Court is trying to find out whether in the subsequent application made in terms of the order of the division bench, whether petitioner applied for transfer to any other school or not.
Yes, my lord, applied, my lord. For that reasons, my lord, kindly turns to page 59 once. Petitioner, in original application, petitioner opted for 3 schools. Kindly see the name of the schools.
Yes, yes.
Belghoria, Domdom, KK.
Yes, yes, I have seen
Such and
them.
such. Now, in the impugned order, page 87, names of the schools are different.
So therefore, according to you,
Yes.
petitioner applied against 3 schools.
Yes, madam. এই তো দেখে নাও না একটা কিন্তু
Not to any school.
not to any school.
অ্যাপ্লিকেশনটা নেই
এই তো
ওটা ঠিক আছে
হ্যাঁ, বলছি।
অ্যাপ্লিকেশনে
করেছিল
অ্যাপ্লিকেশনের মধ্যে কিছু বলা আছে
যেরকম
Initially, petitioner applied for transfer on Utsotsri portal, indicating, giving preference to 3 schools. And petitioner was found to be a single teacher in the subject in the school, where petitioner is presently working. Stop. Ultimately, in connection with the contempt proceedings initiated before the Honorable Division Bench, concerned District Inspector of Schools within bracket AC made a local arrangement in the school of the petitioner by deputing another teacher, resulting in forwarding of petitioner's transfer application to the West Bengal Central School Service Commission for taking decision. Stop. It needs to be stated herein that petitioner made an application for transfer on 4th September 2024 in terms of the order of the Honorable Division Bench dated 29th August 2024. Passed on an intra-court appeal being MAT 1457 of 2024. Preferred by the petitioner. transfer application of the petitioner was finally considered by the respondent number 13, but petitioner could not be transferred as it appears from the impugned memo dated 4th March 2025. Stop. Learned advocate representing the petitioner submits order of the respondent number 13 is not elaborate. And why petitioner's transfer application could not be considered against one of the schools preferred by the petitioner, one of the 3 schools preferred by the petitioner, as was indicated in her transfer application, was not discussed in the said memo dated 4th March 2025. Stop. Next paragraph. Learned advocate representing West Bengal Central School Service Commission within bracket commission, for short commission, has made submission in order to defend the order, of the respondent number 13 as contained in memo dated 4th March 2025, and has also submitted that initially petitioner preferred 3 schools in the transfer application which was made on Utsochi portal, but subsequently when transfer application was made on 4th September 2024 in terms of the order of the Honorable Division Bench dated 29th August 2024, 3 different schools were preferred, as a result whereof respondent number 13 had to consider transfer of the petitioner to one of the 3 schools which was subsequently indicated in latter transfer application. Stop. Next paragraph. On perusal of memo dated 4th March 2025, it appears first preferred school of the petitioner could not be considered due to poor pupil-teacher ratio. So for second and third preferred school where petitioner prayed for transfer, transfer of the petitioner could not be allowed due to pendency of transfer applications by other candidates which were made on medical ground. So, next paragraph. Petitioner made transfer application on any other ground, quote unquote, under Rule 4E and not on the grounds as stipulated under Rule 4A to 4D. Which prevented the respondent number 17 to apply the provisions as contained under Rule 4. Now, amended Rule 6 within bracket 4 within bracket D
2 minutes.
as contained in notification dated 8 September 2021. So, rule amended Rule 4, amended Rule 6 within bracket 4 within bracket D is quoted below. Page 43, D টাকে ইয়ে করে দেবে, set out করে দেবে. Next paragraph. Rule 4D, amended Rule 6 4D authorizes concerned authority of commission to consider transfer application of an applicant teacher to a nearby school which situates near to the opted schools. In the event application for transfer was made under Rule 4A to 4D, so indisputably in the present case, petitioner applied under Rule 4E, not under Rule 4A to Rule 4D. As a result whereof, provisions under amended Rule 6 4D could not be pressed into service. Stop. It is disclosed, next paragraph, it is disclosed in the impugned memo dated 4th March 2025 that against two other schools preferred by the petitioner, transfer applications on medical ground are pending. As a result whereof, transfer application of the petitioner could not be given preference. Stop. Order of the Honorable Supreme Court dated 25th April 2025 passed on special leave to appeal within bracket C close bracket number 11047/2025 reading bracket Chairman West Bengal Central School Service Commission versus Vishwajit Jana and others is relied upon on behalf of the petitioner. Wherein it was observed by the Honorable Supreme Court that when High Court has given one more option to the applicant teacher, and such liberty is always there with the applicant teacher, in terms of the relevant rules, of the West Bengal School Service Commission within bracket general transfer, transfer on special grounds and reallocation close bracket rules 2015. The Honorable Supreme Court did not find fault with giving option more option to the applicant teacher in the matter of transfer. So, but here in the present case, petitioner applied. No, but here in the present case, petitioner applied. But here in the present case, petitioner preferred 3 schools and not more than that. Though petitioner had the option to apply to the schools beyond 3. Stop. Based on such transfer application made by the petitioner, respondent number 13 completed the exercise, which was confined to those 3 schools preferred by the petitioners. Next paragraph. In view of aforesaid discussion, this court does not find infirmity on the order of the respondent number 13 or memo dated memo this does not find infirmity in the infirmity in the decision of the respondent number 13 as contained in memo dated 4th March 2025. Stop. Next paragraph. Hence, no relief can be granted to the petitioner. Stop. However, this order shall not preclude the petitioner to make application for transfer in accordance with law. In future. This writ petition stands dismissed. Urgent xerox copy. আগেই বলে দিয়েছি dismissed. Urgent xerox.
I am for the state, my
Your
lord.
lordship, on a previous occasion, prayer is, my lord.
Just in
It's a assistant teacher, teaching assistant, it's a officer. সেটাকে উইথেল না ঠিক আছে
You have served upon the school.
And sub, they have received.
Anybody is representing the
State
school.
state.
They are not appearing, in spite of your service twice.
When service was effected upon the school in terms of the last order on 11th August,
16th of August, my lord. 16th August, actual 16th. Separate, right? All.
yes, item delivered.
Date and time is given on the second page of the.
Now the format is changed.
Yes, completely changed. At the end, the ultimate delivery status is given.
Previously, it was at the top. Yes,
Summarize the matter on the last order below. Your lordship heard the matter. Two applications made under Utshosri in 2021, school did not forward. Now in 25, another
so
application. has been-
why the school is not forwarding?
No reasons for.
Oh, your application, where is your application?
Page 20, 21 applications, Utshosri or 25?
Oh, the last
Last
application?
application is not at page 43.
What is the date of application?
30th of April, my lord, left hand side.
Page
middle.
44.
Page 43 also, the date is there. Dated 30th April 25.
Now, this is an application on distance.
Distance, my lord, general term.
Distance
No
now.
special ground trade, my lord.
Now, do you have any instruction that why the school is not issuing no objection?
Your lordship.
Because there are certain grounds.
Yes.
There might be, there are not are certain grounds, but there might be certain grounds.
10%.
Say 10% or poor pupil teacher ratio. These are the possible grounds for which generally school does not issue no objection. So do you have any instruction?
Lordship, kindly, I have no instruction, my lord. Kindly,
Very well, then I will direct the DI to submit a report that why the school authority is not issuing no objection.
Let them know.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. In spite of service of notice. Patrashal Radhanagar Bireshwar High School, Hooghly, being respondent numbers 4, 5 and 6 are not represented today. Next paragraph. District Inspector of Schools AC Hooghly, being respondent number 3, is directed to file a report disclosing as to why aforesaid school authority is not issuing no objection on the transfer application of the petitioner. Stop. Let such report be filed by fortnight from date, or let such report be filed by fortnight. List the matter under the same heading on September 2025.
She will get full.
Next,
Item number 8.
Survey copy.
my lord, in this matter Swapon
Yes.
Dotto is appearing, IGP Swapon Dotto is appearing in this matter. I have been requested by Mr. Dotto for taking adjournment. Kindly only adjournment.
he has not come to court today.
No, he is engaging in another. He was first half. He was here.
Not today. Not today.
Great.
Not today. Kal thakbe.
Next.
Item number 9.
Petitioner before in lordship is a group T peon who is taking transfer on the ground of distance. The transfer application pending at the field of the SSC. My lord, status is page number 60. Transfer application dated 26 March 2020. No, yes, 26 March 2022. And it has been ultimately reached to the
15 March 2022.
Yes, it has ultimately reached to the commission on
Applicant to HY, then HY to DI, then DI to again is
to
please
upload the
upload NOC from the
NOC has been
appropriate.
uploaded and ultimately reached to the commission on 12th of April.
Let it be considered by the
Yes.
authority. Distance ground application.
Let's say yes, here secretary is the party. Respondent number 4.
Yes,
Secretary is the party.
is party
Yes, respondent number 4.
4. Yes. Affidavit service filed on behalf of the petitioner is taken on record. Petitioner made an application for transfer on Utsosi portal on 16th March 2022, and thereafter transfer application 2022 stop. School authority where petitioner is presently working forwarded the transfer application of the petitioner to the concerned district institute of schools AC on 10th April 2022 for 10 April 2022 stop. On receipt of transfer application, concerned district inspector of schools AC forwarded the same to the West Bengal Central School Service Commission for taking on 14th April 2022 through portal for taking decision. Stop. Grievance of the petitioner is transfer application is yet to be decided. Next paragraph, respondents are represented by learned advocates who have submitted, perhaps due to suspension of portal with effect from 29 September 2022, contemporaneous decision could not be taken on transfer application of the petition. Next paragraph, however, it is submitted on behalf of West Bengal Central School Service Commission. If concerned authorities directed, transfer application of the petitioner shall be decided in accordance with law. Next paragraph, having considered the submissions made on behalf of the parties, writ petition stands disposed of, directing the Secretary, West Bengal Central School Service Commission, being respondent number 4, to decide transfer application of the petitioner by 6 weeks from the date of communication of this order. Stop. Decision to be taken by the respondent number 4 shall be communicated to the petitioner by 10 days thereafter. Next paragraph, it is made clear that suspension of portal shall not be a ground to reject transfer application of the petitioner. Urgent Xerox certificate. Next.
Yeah. Item 10.
Job loser in respect of the petitioner is seeking my lord counseling in upper primary, in what education, physical education, subject house. My lord, petitioner was
Who is appearing for the commission?
commission I have seen.
I am for the state. in
That I
this
know.
matter.
Who is appearing for the commission? The commission has to be served, to be represented. When you have served,
Yes, my lord, respondent number 2. My lord, I am seeing. That I said that possibly it has not been that service, but it is missing, so I am not claiming that I have some. That give me a
land advocate representing the petitioner.
What it says.
Commissioner.
But I am missing that.
Then you have to file appropriate affidavit of service.
Affidavit of service.
File it, come back. Land advocate for the petitioner is granted leave to file affidavit of service disclosing service of notice upon all the respondents by 29th August 2025. Stop. List the matter under the same heading on 2nd September 2025. Next.
নাম দিয়ে যাবে This is my lord, second round of litigation, my lord, previously withdrawn, that your lordship order is stage 11. My lord, kindly go through it, there is some reading was missing of my part. I hope page 11. Paragraph number 2 and 3.
Yes.
My lord, that time, my lord, due to holiday, my lord, no head of the institution not available, president issued the NOC.
But can it be done?
Yes. My lord, as per
In case of assistant teacher, no objection has to be granted by the head of the institution.
my lord, head of the institution, but as per rule, my lord, 2021 SMC. It has been quoted.
No, it has to be by the head of the institution.
Ultimately, my lord, it has been adopted by the subsequent resolution. That resolution I have annexed. My lord, page 29, your lordship may find.
For me, that in case of a transfer of a primary of an assistant teacher of a secondary school, president can issue no objection.
Yes, my lord, that as per rule, my lord, rule 20, my lord, SMC. Kindly see rule 6. Rule 6, my lord, SMC term is previously, it has been stated, rule 15, it has been classified.
Which rule? Rule 6.
Rule 6, my lord, yes,
Rule 6?
Yes, my lord. Previously, my lord, if your lordship considered rule 6 of earlier 2015 rule, my lord, 2015 rule, I have only one copy. Rule 6, sub rule 3, my lord, 2015, may I read the head of the.
Just a minute.
Your lordship. That I am not. আমি পেজটাই ফরম্যাটিং করেছি।
Rule 6, sub-rule 1 says that the SMC shall consider not to issue no objection.
Rule 6, no errors were given on 6th of May 2025 and resolution adopted on
No, come to rule 6 as contained in notification dated 8 September 2021, amended rule 6.
Amended.
Or substituted rule 6, whatever you may call. An incumbent may apply for transfer on ground and manner mentioned in rule 4. The respective authorities involved in the process of transfer, that is school managing committee, shall consider such transfer application. But where is the provision relating to issuance of no objection?
SMC has all stated rule 6 is the ultimate matter signing upon submission of the application. The authorities of SMC shall enter SMC subject to my lord corrections. Head of the institution is the head of the president is the head of the managing committee. So the president can
Just a minute. Rule 62G.
Yes.
But there is no indication that the head of the institution will issue.
No, the TDS rule seems like the division bench directed that everything has to be done in prescribed
The
form.
submission of application upon submission of application, authority of school managing committee shall issue no objection. The president can.
Rule 15, my lord, rule 15, it has been.
Authority of school managing committee shall issue no objection.
My lord, kindly see the TDS.
So where is the bar if president of the managing committee issues no objection?
They are preparing this application, my lord, pursuant to the direction of the Honorable Division. No, prescribed format.
Yes, let him submit. Yes.
My lord, pursuant to Honorable Division bench in another matter, my lord, directed the applicant to apply in prescribed format. See, the prescribed format, my lord, provides that the signature of the secretary of the, or the TIC or the administrator is required. Therefore,
How that can be? That is contrary to the rule.
TDS rule, it has been.
No,
Then another.
no. My lord, page 24, signature of the headmaster, headmistress, teacher in charge of the school, or secretary of the managing committee. Or
But if prescribed format is not in sync with
administrator.
62G, then rule 62G will prevail. Rule 62G says upon submission of application, the authority of SMC shall. The president can.
Secretary, managing committee or administrator.
Subsequently, managing committee adopted it by a resolution which.
But he is a single teacher.
Yes.
That is different thing. That is different thing.
Yes,
Question is whether the president can issue
the
objection or not. There is no express bar, and not only this amended rule 62G says that upon submission of application, authority of school managing committee shall issue.
Also prescribed format.
Now prescribed
NOC
format says
secretary or administrator.
Administrator. That if prescribed format is not made in accordance with rule 62G, then in rule 662G will prevail. That is the statutory provisions. Court will not follow prescribed format. What is printed therein.
It is distance ground transfer application, school issued the NOC. I am the single teacher. I have stated in my application, rate 3rd January 2022. 9 ACB followed and take a suitable decision by the teacher. That is fine.
Where is your application in the prescribed format?
Prescribed format, page 21. Oh, I am facing some medical issue, but it is not a notified visit, so it is on distance.
Normally, head of the institution does in case of assistant teacher or non-teaching staff, or in case of headmistress, secretary will do or president will do it normally. But there is no prohibition. Rule is not restricted to the head of the institution to issue no objection in case of assistant teacher or non-teaching staff.
2015 rule takes the prohibition. 2015 rule, my lord, just stated head of the institution. My lord, kindly see rule 6.2. The power has been given to the SMC. So, my lord, NOC must be qualified by the reasoning of a resolution adopted. My lord, rule prior to issuance of the NOC.
That is what is important is resolution.
My lord, here in the present case, my lord, NOC was given on, my lord, 6th of May 2025. Resolution was adopted.
Subsequent. Ratifying that decision.
2015 rule 6, my lord, sub rule 3. The head of the institution, the secretary of managing committee, that means head of the institution or administrator, as the case may be, concerned school shall issue no objection certificate to the incumbent of recommended of general transfer under the regulation. So it was 2015. Subsequently, it has been rewrite as SS.
Now, where this application is lying?
Lying, my lord, it is the head of the institution. since but after issuing the
lying before the head of the
head
institution.
of this, it required to forward to the
So
DI.
why the head of the institution has not forwarded it?
Forward, that is the case. But I have served the NOC as a subsequent resolution, my lord, agenda number 6. It has been adopted by the school authority. No. My lord, it has been stated, I am a single teacher, I am not disputing. No, starting process is not notified. Yeah. হ্যাঁ 5 বছর অবশেষ
Issue.
My lord, may I leave? My lord?
Affidavit shall be filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner made an application for transfer in prescribed format. In prescribed pro forma. In prescribed pro forma. When this application was made,
Yes,
no
my lord,
date.
application is made on my lord, date of 6th of May 2025. My lord, it is not that
In
stated
prescribed pro forma,
May 2020.
seeking transfer on general ground within bracket distance. Stop. President of the managing committee of ধারবনী শারদামণি বালিকা বিদ্যালয় within bracket HS, পশ্চিম মেদিনীপুর, issued no objection in favor of issued no objection on transfer application of the petitioner on 6th May 2025. Stop. Next paragraph. It is submitted on behalf of the petitioner that till date transfer application of the petitioner has not been forwarded to the concerned district inspector of schools, AC Poschim Medinipur, being respondent number 5 for taking further steps on transfer application of the petitioner. Stop. Stop. It is also submitted that petitioner is single teacher in the subject in the school. Therefore, steps are required to be taken by the concerned respondent authorities in terms of government notification dated 3rd January 2022. Where is the managing committee resolution?
My lord, managing committee page 20, relevant page 28, agenda number 6, started from 27. Started from 27 and it is
One managing committee resolution dated 28 June 2025.
agenda number
Is annexed, one managing committee resolution dated 28 June 2025 was adopted by the said school authority, by the said school authority or by the managing committee of the said school. Ratifying the no objection issued in favor of the petitioner on 6th May 2025. Where is ratification under which paragraph?
paragraph 6, that is page 28.
কি বললাম ratifying? Stop. Next paragraph. State respondents, West Bengal Central School Service Commission and board are represented by learned advocates. And it is submitted Since with a managing committee resolution dated 28 June 2025, transfer application of the petitioner was accepted, and it was decided that steps are required to be taken in terms of the relevant government notification, since petitioner is single teacher in the subject in the school, comma. Transfer application is required to be forwarded to the the respondent number 5 for taking necessary steps in terms of government notification dated 3rd January 2022. Stop. Next paragraph. Having considered the respective submissions made on behalf of the parties and taking note of the decision taken in the managing committee meeting dated 28 June 2025 relating to transfer of the petitioner, comma. Respondent number 6 is directed to forward transfer application of the petitioner to the respondent number 3, to the respondent number 5 by fortnight from the date of communication of this order. Stop. On receipt of transfer application, respondent number 5 shall make an endeavor to find out a teacher of neighboring school who can be deputed in place of the petitioner in the event petitioner is transferred. Stop. If a teacher is found from neighboring school who can man the post of the petitioner on his transfer, comma, petitioner shall be transferred in accordance with law immediately thereafter. Next paragraph. Writ petition stands disposed of or এগুলোকে দিয়ে দেন। Next.
Item number 2.
Yes.
I'm for
And for secondary.
To PPO before your lordship seeking general transfer pending at the commission.
On many occasions, you have prayed for transfer. There are so
Yes,
many
but-
applications.
Yes, but all such application returned by the authority that low score secured by the candidate, there is no vacancy. I am relying, my lord, serial number 16 back from the SSC. All are general ground transfer application. Serial number 16 back from SSC. Please submit the prayer of enrollment low in the present enrollment low. Subsequently, my lord, rejection again 10 serial number 10.
No, but serial number 10, nothing is stated.
As
As per
per
prayer
dated
dated
7
7 March,
transfer.
prayer for transfer is returned.
No observation.
Yes.
As per prayer.
How many occasions he will take chance to get transferred?
Well, since my application is pending before the authority, let it take a decision at least, my lord.
You tell me what is the situation?
My lord, a
It is
school is-
pending from 2022, madam. And the ground is for treatment of his mother who is suffering from cancer.
No, I'm distance ground. My mother is suffering from cancer.
But that
I
cannot be a
know.
mother's illness cannot be a ground.
Yes, I'm not on. My application on general ground. But allied issue, my lord,
Medical documents are of 21 and 22.
Last application was on 10 July 2022.
is in July 2022. It had reached to the commission 25th of July 2022.
But it is stated that he needs an urgent transfer for the treatment of his cancer patient mother, and the school will not suffer for this transfer, for his transfer. So is it on the medical ground or on the ground of distance?
Mother,
They have not annexed the application.
Application was made on Utsosi portal. How application will be annexed?
Your lordship, nothing to show on record. What was the ground on which he applied?
I have stated in my application, distance ground transfer application, mother shall not come under the zone of consideration. Spouse, child, and said that.
Mother's illness is not a ground for transfer. So treat this application as a general transfer application and take a decision. And if the said this transfer application is rejected, petitioner an undertaking will be recorded that no further application is to be made by the petitioner in future seeking transfer. Only then court will pass the order. You are coming after 3 years, and that probably is the 10th application or 8th or 10th application. So there will be no further application for transfer in future. That will be the last application. Otherwise, petitioner shall remain in the school till his retirement.
If my learned friend cooperate with me, then I will facilitate transfer. No problem.
It is to be recorded.
He need not come. If my learned friend is also giving undertaking, I will cooperate.
How long you will go on making applications? One after another, one after another. There is no bar in making several applications.
It shows that he is in urgent need of transfer.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph, petitioner made transfer application last on 10 July 2022 on Utsotsi portal on general ground within bracket distance. Stop. Transfer stop. Transfer application of the petitioner was forwarded by the school authority where petitioner is presently working to the concerned district inspector of schools within bracket AC for taking further steps. Stop. The district inspector of schools within bracket AC in his turn processed the transfer application and forwarded the same to the West Bengal Central School Service Commission for taking decision. Stop. Grievance of the petitioner is transfer application his transfer application dated 10 his transfer application which was made on 10 July 2022 is yet to be decided. Stop. Petitioner prays for consideration of his transfer application by treating the same as an application made on the ground of distance in between the present school of the petitioner and his place of residence. Stop. Next paragraph. Respondents are represented by learned advocates who have submitted perhaps due to suspension of portal, contemporaneous decision could not be taken on transfer application of the petitioner. Stop. Next paragraph. On behalf of West Bengal Central School Service Commission, it is submitted if concerned authorities directed transfer application of the petitioner shall be decided in accordance with law. Stop. Next paragraph. Having considered the respective submissions made on behalf of the parties, writ petition stands disposed of, directing the Secretary, West Bengal Central School Service Commission, being respondent number 4, to decide transfer application of the petitioner by 6 weeks from the date of communication of this order. Stop. Decision to be taken by the respondent number 4 shall be communicated to the petitioner by fortnight thereafter. Next paragraph. It is made clear that suspension of portal shall not be a ground to reject transfer application. Upore dispose of bole diyechi tai to. Urgent Xerox copy.
Next.
Appear on behalf of the petitioner. File the affidavit service law. Failure to file the affidavit service law. This is the second round of litigation. The husband of the petitioner firstly filed the application before this honorable court, and Justice Kapoor has been pleased to pass an order. The husband of the petitioner initially appointed as a clerk in a school, high secondary. Thereafter, he promoted in the year 1987 as the assistant teacher. Thereafter, he retired, and there is a wrong fixation. The amount was deducted from the retirement benefit. Thereafter, he challenged that, and order.
When you retire?
I retired on
Husband.
husband of the petitioner. They
Husband retired?
My lord.
21.
20, no, 19.
When retired?
My lord. Retired 28th February 2013.
Oh, sorry, 13.
What is your grievance? What you are
May I
praying?
kindly see,
Why? What the petitioner is praying for?
I kindly see page 11, paragraph, annexure P2. There was an order of this honorable court. Thereafter, the commissioner of the school passed an order that my deduction was illegal, and again
Your
deduction was illegal, and again I will get another increment for the 10 years benefit. And kindly see the operating portion of the order, annexure P2.
চার্ট প্রিপেড হয়নি, প্রিপেড হলে আপনাদের নাম্বার দিয়ে দিচ্ছি আর টিকিটের, ঠিক আছে?
Last part, one paragraph.
ঠিক নাম্বার। আপনার মক্কেল খুঁজে দেখেছেন তো? মক্কেল খুঁজে দেখেছেন তো?
না না
কাছাকাছি থাকলে দেখে নিতে পারেন।
না ডাকবো না, তার কারণ হচ্ছে যে আপনার মুশকিল হয়ে যেত।
is which document you are relying upon?
Page 11, annexure P2.
So this order, have you challenged this order?
No. I am want the implementation of this order.
Implementation of this order. This order comes in your favor.
My lord. Can you see the last paragraph? My lord, thanks.
Yes, why it has not been implemented?
Yes, my lord. Hereafter, my lord, husband, my lord, the teacher concerned died, my lord. Thereafter died, my lord.
Yes.
And my lord, thereafter, my lord, my specific instruction is, my lord, if the pension case of 2013, within certain period, my lord, DL is, my lord, searching on, my lord, working on the pension.
Page 16, my lord, kindly see.
Revise.
You are now getting family pension,
Yes,
but at a reduced rate.
reduce.
All the documents has been submitted, page 16, by the headmaster of the concerned school in the year 2023, last annexure.
Just a minute. Yes, it has been decided by the Commissioner of School Education. First petitioner was a clerk. Subsequently, he was promoted. He was not it's not a promotion. He was appointed as assistant teacher on 6 January 1987. So first 10-year service benefits as clerk, then subsequent 10-year service benefits as assistant teacher. That is found to be permissible even in terms of ROPA 2009.
Yes.
So therefore, the commissioner decided that deduction of rupees 63,815 was wrong.
Yes.
And not only that, there is a requirement of issuance of revised pension payment order granting this incremental benefits, which was payable to the petitioner on 6 January 2007, being an assistant teacher. So why this has not been implemented?
After that matter, after the order passed by the commissioner, the teacher concerned expired on
11th November.
11/2021.
Expired on
11th November 2021.
Yes.
এই তো চিঠিতে লেখা আছে পেজ ফটো
It's
11th
November 2021.
Yes,
Thereafter I made
but that does not that cannot be a ground for not
Certainly,
implementing
I'm
the
not,
order.
I'm not standing, Manat. Thereafter, Manat, wife Manat resubmitted all her documents, and that was reached to the District Inspector of School on 7th of November 2023. Manat, my instruction is, Manat, we are working on it.
We have to pay interest on this.
Manat,
On this 63,000, you have
Yes,
to pay
yes.
interest from the date of retirement till the date of release. Because this was wrongly deducted as it was decided by the Commissioner of School Education.
I have seen, Manat. I have seen, Manat, even Manat, the commissioner order and Manat, PI action also. But only
So let me I am disposing of this writ petition, directing the district inspector of schools to issue revised pension payment order strictly in terms of the order of the Commissioner of School Education, and also release the deducted amount of rupees 63,815 along with interest for the period from the date of retirement till the date of release. It was deducted from your gratuity.
my lord. From the gratuity of my husband.
Yes. Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Learned advocate representing the petitioner submits husband of the petitioner was an approved clerk of a government aided school and who discharged duty as clerk from 5th March 1973 till 5th January 1987. Stop. Thereafter, husband of the petitioner was appointed as assistant teacher in the school on 6 January 1987 and retired on superannuation from the post of assistant teacher on February 2013. benefits which were payable to the husband of the petitioner was considered by the Commissioner of School Education, West Bengal, and an order was passed on 24th August 2020, wherein it was decided that husband of the petitioner was entitled to one additional increment on 6 January 2007 for completion of another 10-year service as assistant teacher in the school. Stop. District Inspector of Schools AC Hooghly being respondent number 3 was directed to issue revised pension payment order and to refund the amount which was deducted from the gratuity of the husband of the petitioner, that is rupees 63815. Even and was ki bollam and last 63815. Stop. Next file. Learned advocate for the petitioner submits till date order of the Commissioner of School Education dated 24th August 2020 is not implemented. Stop. Meanwhile, husband of the petitioner died on 11th November 2021. As a result whereof, widow being the petitioner has approached this court with the present writ petition for extending the benefit of the order dated 24th August 2020 passed by the Commissioner of School Education. Next paragraph, state respondents are represented by Mr. Chattopadhyay, learned advocate, who has submitted the steps are being taken by the concerned state respondents for giving effect to the order dated 24th August 2020 passed by the Commissioner of School Education. Next paragraph. Since it has already been decided by the Commissioner in the memo dated or in the order dated 24th August 2020 that husband of the petitioner was entitled to one additional increment on 6 January 2007 for completion of another 10 years service as assistant teacher in the school. It was rightly decided that that concerned state authority is required to issue a revised pension payment order and to refund rupees 63815 to the petitioner. Stop. Astonishingly, till date, order of the Commissioner dated 24th August 2020 is not implemented. Next paragraph. Having considered the respective submissions made on behalf of the parties and taking note of the decision of the Commissioner of School Education as contained in memo dated 24th August 2020, District Inspector of Schools SC Hooghly being respondent number 3 is directed to issue revised pension payment order strictly in terms of the memo dated 24th August 2020 issued by the Commissioner of School Education West Bengal and refund rupees 63815 within a period of 4 weeks from the date of communication of this order. Stop. The refunded amount, that is rupees 63815, shall carry interest at the rate of 8% per annum from the date following the date of retirement of the husband of the petitioner till the date of release in favor of the present petitioner. Stop. Writ petition stands disposed of. Urgent Xerox certificate copy. Done.
Mr. Item number 14.
I am appealing for state respondent,
Extension.
led by Mr. Pinagi Dhol.
Extension of recommendation of upper primary sector beyond 90. Beyond 90 days, I have a job user in respect of 2016.
Have you taken decision?
No, Your
Beyond 90 days, application seeking extension of validity of recommendation.
No, Your Lordship. But it appears from page 90, Your Lordship. That is on January 6, 2025, school given 15 days extension, my lord. Page 19. And he made representation to the commission for the first time on 8th April.
But it was decided by the school authority. How the school authority can do this if it is within a
There was a
period of
fact-
90 days
But petitioner did not join. Then the school authority gave 15
when the
days
recommendation was issued.
Recommendation on
November, my lord.
page, my lord, page 16, 19 November 2024.
You are job loser.
I'm jobless, sir.
Where is your application?
My lord, application is, my lord, page 20, 8th April 2025.
You are still working.
Page 25, my lord. Please.
Same order. Take a decision, chairman to take. Disposed of. এটাকে দেখে করে দেবে, corrections গুলো দেখে নেবে। Next.
My lord, I am appearing for the statement.
Yes. Item number 2.
Service to the chair.
Next.
Lord, 15 Lord, I am appearing for the petitioner. Lord, this is my lord granting the benefit of addition. Please to in the matter decision number 1 is concerned, that is not addition Q1, and then the link was granted to file have place on the social further action.
What is that? This is the order passed on the earlier occasion. This is still working. But commissioner is not a party. I don't know, you make a representation to the commission. Press representation you make to the commissioner within 3 weeks. এটাকে করে দেবে প্যারাগ্রাফ 2 টাকে শুধু দেখো না, প্যারাগ্রাফ 2 টাকে বাদ দিয়ে দেবে, কিছু কারেকশনস করে দেওয়া আছে সেইগুলো দেখে নেবে। Disposed of. Make a representation within 3 weeks before the commission. Next. All the matters from combined list.
Item number 4, monthly list of appellate site.
Madam, for the state of it.
Yes. Assistant teacher. Retired on.
2017.
Past PPO. Revised PPO.
2021.
Revised PPO 14th February. Disposed of. Here for the state. Next.
Item number 4.
Statement.
Yes, assistant teacher. Retired on.
March 2018.
Past PPO.
2018.
Revised PPO.
November 2021.
Assistant teacher revised PPO 14th February. Disposed of. Next.
Item number 3.
I'm praying for not today.
You are appealing. You are appealing for whom? Why not today?
My target
Now
is
they can file them.
for the still he's ended in code number 9, my lord.
What is the matter? Transfer.
With respect to our challenge of appointment for the assistant. I was one of the participants. I alleged that they have been favored at school. But I said that my basic ground for challenge to a lot is that
It's a writ petition of 2024. Appointment has already been made.
but appointment was made at the time when this matter was filed itself.
Where is the service upon respondent number 8? I think respondent number 8 is the appointed candidate.
Yes, but I have served upon that as late as 19th of August 2020.
2025.
Point number 8 I did to us.
File your affidavit service.
I'm just giving you a the exact date. Right. I think the 15th of August 2025.
You are the candidate who, you are a teacher who participated in the selection process. Where are the illegalities?
I have alleged that initially there was a previous appointment process of the assistant headmaster. Who suggested the appointment of assistant headmaster provides the specific construction of the committee for selection. That was not adhered. I challenge that I made representation. That previous appointment was cancelled. Second appointment
Selection process.
was but I apprehending this favoritism. I wrote to them that let this interview process at least be videographed. So that was not done. That does it. So now our situation remains. I was not even intimated with what numbers who have got, but from reliable sources which have stated on affidavit that I have said that I myself, apart from the fact that I am the senior most, but I have got 30 marks out of the total 30 marks, which is on merit. But I have got 5 marks in experience out of 5. But in Viva, I have got 1.8. On the other hand, the incumbent respondent number 8, who has got on merit 26 and on experience 4.
On merit, what was your marks?
29 out of 30. So his was 27. And I got 1.18 Viva, and he gets 5 out of 5. And accordingly,
But what is the what interim order can be passed at this point? And you are submitting the respondent number 8 has joined the post. So let it be decided on exchange of affidavits.
The contention that I made, this school really comes up with the affidavit matter that.
Because at the motion stage, there is no scope for passing any interim order at this belated stage, since this writ petition was filed on 12 March 2024.
And the second matter is also with respect to my challenge for appointment as TIC. Same.
In the same school. How TIC and
Well, at that particular time, there was no headmaster or assistant headmaster. So there was a selection, there was a meeting for appointment of TICL. And there also,
but where there is an assistant headmaster, TIC is not required.
At that particular time, there was no such assistant.
At that point of time. So that TIC is still functioning.
But,
along with the assistant headmaster.
But the assistant headmaster, who is the right now assistant headmaster, is the TIC. That is the case. Now,
that writ petition, according to my estimation, has become infructuous. Because it's for a limited period, that scope was there for TIC. Whenever your submission is this, that the TIC was first appointed. Why TIC was appointed? There was no assistant headmaster. Subsequently, same person was appointed as assistant headmaster. At the time when the same person was appointed as assistant headmaster, so question of TIC does not arise. It has become infructuous, Mr. Rai.
I just request your lordship if both these matters are taken up together and instead of.
First matter I will admit, second matter I will dispose of or dismiss, since it has become infructuous.
As your lordship, because the TIC post
is no more in existence in view of appointment of assistant headmaster.
Second matter.
Yes.
I just pray.
Second matter I am appearing.
Only one thing I was just praying, if the appointment of the assistant headmaster in the past matter implies somehow and then my scope to become the TIC also. If this could have been
For that you will take steps in accordance with law at that point of time, because TIC post is abolished or TIC post is not in existence. Now, if your writ petition is ultimately decided in favor of the petitioner, in that occasion, fresh appointment is required to be made in the post of TIC. Because first TIC was X was appointed as TIC. Respondent number 8 was appointed as TIC. Now, subsequently, respondent number 8 was also appointed as assistant headmaster. So TIC.
In the second matter, someone else has been engaged as a TIC.
Someone else was engaged as TIC. Now, whenever a TIC was appointed, assistant headmaster was appointed, TIC's presence is redundant. So therefore, there is no need to appoint TIC. Now, ultimately, if your writ petition succeeds in that event, the question of filling up the post of TIC will come into consideration by the authorities, and for which fresh process is required to be initiated. That TIC who lost his post due to filling up the post of assistant headmaster cannot claim appointment straightway. What is the position on that after allowing your writ petition that has to be taken into consideration while engaging a new TIC?
Only I was just saying, since both these matters have been taken up together.
Affidavit of service filed on behalf of the petitioner is taken on record. Now, the first matter I'm just passing separate orders. Taken on record. Stop. Petitioner, land advocate representing the petitioner. Engagement of respondent number 8. Engagement of respondent number 8 as teacher and as assistant headmaster of Surya Maulana Azad High School,
ঠিক আছে
North 24 Parganas, is questioned. Selection process which was followed by the authority of aforesaid was followed by the aforesaid school authority is also questioned, and outcome of which was selection of respondent number 8 for the post of assistant headmaster. Stop. Next paragraph. It appears from the submissions made on behalf of the parties that respondent number 8 was already appointed as an assistant headmaster in the school. Therefore, there is no scope for passing any interim order at this stage. Next paragraph. Issue needs to be decided on exchange of affidavit. Stop. Let affidavit in opposition to this writ petition be filed by 4 weeks from date.
ঠিক আছে
Yes, 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks after preservation. Stop. Petitioner shall be at liberty, or party shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next, all parties are present. School authority. Respond number 8.
Please appear on behalf of the school authority. Respond number
See
8.
for the state. You are for the state.
No. School authority.
You are for the state.
Second matter state.
Respond
First
number 8.
I'm for the state in the first matter.
So, learned advocate for the petitioner is directed to communicate this order to the non-appearing respondents by 7 days from date and file further affidavit of service on the next date. Yes, call the next matter.
Item number 414.
ওটা দাও, ওটা লাগবে আগের ফাইলটা।
এটা তো নয় এটা নয় অভিজিতের তো সাকসেস অন্য লোক মানে with regard to second matter Malad Rahul Ganguly, he participated in selection process. Malad he became third position and he has challenged the Malad appointment of Malad respondent number 8 Obhijit De. Obhijit De
You are representing the petitioner in this matter.
Did not appear in the panel. He has not been appointed and his name is not appearing in the panel.
What is saying that this writ petition has become infructuous. Why? Because in the same school subsequently assistant headmaster was appointed.
Yes.
When an assistant headmaster is appointed in a school, there is no scope left open so far TIC is concerned to function.
My lord.
Because this matter concerning selection of TIC. Now that has been questioned, selection of TIC is questioned by the petitioner, by a separate petitioner, not by the same. Now TIC can function till appointment of assistant
headmaster.
As and when assistant headmaster is appointed,
TIC
cannot function. The person who has been engaged as TIC cannot function. So matter has become infructuous.
Yes, my lord.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. In this writ petition, selection of respondent number 8 as teacher in charge of Surya Maulana Azad High School, North 24 Parganas, is under consideration. Is questioned. Stop. However, it is submitted by the learned advocates representing the parties that subsequently in the school, post of assistant headmaster was filled up by another candidate. No, by appointing another candidate. No. It is right that after engagement of assistant headmaster in a school, teacher in charge cannot function. Stop. Hence, this writ petition has become infructuous. Stop. The writ petition stands dismissed as infructuous. Urgent xerox.
Record that my assistant headmaster would have been valid in a different writ petition. But otherwise, this would be a this would not see that.
Why?
Because they would have always said that only because of this fact, the lordship has accepted that appointment of assistant headmaster is already there. On a type B. So for the deputy is only this line mentioned that the challenge to the appointment assistant headmaster is already under challenge.
Yes. At a line issue. আগের ইনফ্রাস্ট্রাকচার সেন্টেন্সটা বলো না stop infrastructure stop it needs to be recorded herein that selection for the post of assistant headmaster in the same school has been questioned by filing another writ petition being WPA 7643 of 2024 and the said writ petition is pending for final consideration.
By another person.
No, by not by. No,
Same person.
By same person. Stop. Next paragraph. However, present writ petition stands dismissed as infructuous. Again.
Because that senior says that the incumbent that I have made the private responding TIC matter is not TIC anymore. The agent is the TIC.
It has become in second writ petition.
First petition is concerned, I'm appearing on behalf of the school.
Next matter, give your presence. Your presence is justified. Give your presence. Yes.
Item number 5.
Yes. But we will file our opposition in this respect. Yes. What is the matter about? This writ petition was filed on 12 March 2024. What is the matter about? You are? Yes, very well. You place your case. Please place your case. What you are prayed for? If I find that Mr. Bhattacharya's assistance is required, I will adjourn the matter. First, place your case. Where is your brief?
29 এটাকে কষ্ট করে চেয়েছি
Cause of action is at page 29.
Date for change of increment done or not. Date for change of
What non-functional increment? You are aware of non-functional? We know stagnation increment. We are aware. What is non-functional?
ওদের এখানে ইউজ করেছে কি?
Yes. Your petition, what instruction is required? And you will make some submission being prompted by a clerk. Yes. Who is the advocate on record? Where is he? Are you engaged in this matter? Are you an advocate on record? No. Yes. At the time of call, accommodation is paid for on behalf of the petitioner. So, however, you are for the state. However, state respondents are represented by the advocates. Acceding to the prayer made on behalf of the petitioner, hearing of this matter stands adjourned. List the matter under the same heading in the monthly combined list of September 2025. However, it is made clear if on the next date. However, it is made clear no further adjournment shall be granted on the next date. Next.
Item number 6.
Lord, I am for the state, my lord.
This is a challenge. Dealt with this kind of matters in division bench, Justice
shared as well as in the single bench also. Well, this is that 3% additional increment to the headmasters and 200 grade pay. My lord, that notification of that has been withdrawn by a notification dated 12th of March 2017. That is under challenge. My lord, coordinate bench already
Subir Ghosh.
Monoranjan sir.
The judgment of Justice Rai Chattopadhyay.
Yes, after that also, relying upon that, Parthasarathy Chatterjee has passed an order.
Past judgment is.
Subir Ghosh, the Vishwas has.
Yes.
And my lord, there are also.
So you are claiming 3% additional increment?
Yes.
We had a mutual order. You are working or has retired?
What?
Still working. Have you made any representation?
Yes, sir. Representation is paid, my lord. 7.
In the case of representation, give me an order. Take it out. There is also a division bench order of Kalishadan Bhattacharya.
I know, my lord, the matter has been remanded back.
Where is your representation?
Page 37.
It's an advocate's notice. It's a demand justice. Where is your representation by the petitioner?
Representation.
So therefore, I will grant you leave to make a representation to the commissioner within a certain time, and that will be considered in accordance with law. Relying upon Kalishadan Bhattacharya as well as it's not required. Following ratio of Kalishadan Bhattacharya and Sumir Ghosh.
Another.
Not required, please.
No.
It is not required.
Giving it, and the judgment is there.
Not required. Please take your seat. Allow me to pass an order. Yes.
করতে হয় এই অর্ডারেই করে দিই
You made Commissioner of School Education party?
Yes.
Respondent number 2, my lord.
Yes. You will make a representation by 3 weeks from date to the commissioner. Commissioner shall take a decision after granting opportunity of hearing to the petitioner. And while taking decision, commissioner shall follow the ratio of Kalishadan Bhattacharya and Subir Ghosh. Disposed of.
Deeply obliged, my lord.
Okay, next.
Item number 417.
Area pension interest. Learned advocate representing the petitioner submits that on similar issue, matters are pending before the Honorable Division Bench. Next paragraph, hearing of this matter stands adjourned. Next paragraph, list the matter under the heading motion in the monthly combined list of November 2025. Next.
Item number 418.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Writ petition stands dismissed for default. Parties to act on the server copy. Next.
Item number.
Yes.
Okay, list the
Page 20.
But তাড়াতাড়ি আসতে বলো। 2 ঘন্টা ঘুরে গেছে।
Yes, Kamruzzaman's case.
I'm the second petitioner. Therefore, in this matter, content has been prepared. Content petition, they are filed the complaint. The petitioner, Jaymatma is not present. Therefore, I submit the my pattern copy. Therefore, no step has been taken. No reassessment, nothing.
On your carbon copy, how reassessment can be made?
Therefore, I.
Yes.
Then page 56. I get it. This is clear. 56.
Last evening.
I go to the instruction list.
Now, why OMR of the petitioner could not be found? Why, while OMR of others were found, made available?
No, the 2011 selection process, when the panels expired in 2015, then the litigations, when the matter was being heard by the court in 2022,
But
2023.
there is a writ petition of 2013.
Yes.
And petitioner is the second.
But this was agitated before the coordinate bench, and the coordinate bench accepted the position. And it was on that basis the candidates, those who we could not trace, we had pointed out to the court that why is the entire onus being put on us in such a that since the candidates were given OMR sheets, they should have also managed. We pointed it out to the court that candidates also have a copy of the OMR. Let them bring it. So it was for the.
You have a copy of OMR?
All, yes.
Which I have submitted.
So carbon copy has been submitted?
Yes, then subsequently all the assessments were done and the entire thing was concluded, and out of 73 candidates, 63 candidates were allowed.
No, petitioner here is submitting that since OMR sheet was not available with the commission, that's why the exercise which was required to be carried out in terms of order dated 29 June 2020, that was not done.
That specific instruction I will have to take because that entire thing was concluded, and even in the contempt.
What is your case that your OMR was not assessed?
Then after submitting my OMR sheet, they filed a affidavit and they admit that the OMR sheet is not legible. They destroyed my OMR sheet. Carbon copy. I submitted, and they say your OMR sheet is not legible.
Yes, Dr. Patro. It is not a case that that it was assessed and petitioner was not found eligible. It is a case which is being made on behalf of the petitioner is that there was no assessment of OMR sheet since the OMR was not legible. And petitioner submitted carbon copy of OMR sheet.
Yes. So let me take the candidate-wise instruction with regard to this candidate. What happened? Whether
the single petitioner.
Yes, now only this one candidate. Yes. If I remember correctly, only 2 candidates were requested to bring their OMRs. And those who did not have, possibly the court did not even allow their assessments. That I'm saying from my memory, I will also check that. I will check. That I will check.
File a report.
Very well.
File a report in the form of affidavit.
Yes.
What time is not possible? It will be included in the monthly list. The writ petition of 2024. Issue. Matter is.
No, nothing.
Matter is heard in presence of the learned advocates representing the petitioner and respondents. So, it is you are the second petitioner in Kamruzzaman's case. It is submitted by the learned advocate representing the petitioner that he was second petitioner in the writ petition being WPA 450 of 2013 within bracket MD Kamruzzaman and others versus the state of West Bengal and others, which was disposed of by a coordinate bench. Video order dated 29 June 2022. Stop. It is also submitted that Weimar of the petitioner was not assessed in terms of the directions as contained in the order dated 29 June 2022. Passed in WPA 450 of 2013. Passed in the writ petition being WPA 450 of 2013. Since it was found by the concerned authority of West Bengal Central School Service Commission that OMR was not legible. According to the petitioner, carbon copy of OMR was supplied to the concerned authority of West Bengal Central School Service Commission, and prayer is made for assessment of OMR in terms of the order dated 29 June 2022. Next paragraph, Dr. Patro, learned advocate representing commission, has prayed for accommodation to obtain instructions. Next paragraph. Concerned authority of the commission is directed to file a report in the form of affidavit disclosing whether OMR of the petitioner in connection with 12th regional level selection test 2011 was assessed.
OMR with regard to the TET examination. RLST paper was a written exam.
Written.
The OMR was the text.
তিনটে স্টেপ বলো। Now, in connection with TET, TET which was linked to 12th or
yes. So TET 2011.
Now, whether OMR of the petitioner relating to TET 2011,
yes,
relating to teacher eligibility test 2011, which was conducted prior to 12th regional level selection test 2011, was assessed or not, and if OMR is not assessed, the reasons for not assessing OMR in terms of the order dated 29 June 2022 passed in the writ petition being WPA 450/2013. Stop. Let such report be filed by 3 weeks from date, by 2 weeks from date.
No, 3 weeks. This matter has been decided by the coordinate bench. In the contempt, when the court held that there is no further contempt, it meant that all the candidates, whatever we have done with
Let
them,
such
the
report be filed by 3 weeks. Let such report be filed by 3 weeks. Yes, I am aware of this order passed in contempt. Let such report be filed by 3 weeks from date with a copy upon the learned advocate representing the petitioner. Next paragraph, list the matter under the same heading in the monthly combined list of October 2025. Next. হ্যাঁ বলো। Was assessed or not? Now, if OMR was not assessed, the reasons for not assessing said OMR. Said OMR. Yes.
Item number 420.
I am for the state, my lord.
Requested me to play for an adjournment of the day.
Why adjournment?
He has not come to the court. That's why my lord.
Why he has not come to court? Taking rest at home. We are all working. Matter is taken up after such a long time. This matter has never been touched. Writ petition was filed on 14th March 2024 and prayer will be made.
That's why my lord.
At the time of call, accommodation is paid for on behalf of the petitioner, since learned advocate is not present in court. However, state respondents are represented by learned advocate. Next paragraph. Hearing of this matter stands adjourned. List the matter under the same heading in the monthly combined list of September 2025. It is made clear if on the adjourned date, no further adjournment shall be granted on the next date. Next.
Yes. I'm ready.
Item number 421.
Yet to appear.
Yeah, for the state. At the time of call, no one appears for the petitioner and no accommodation is paid for. However, state respondents are represented by learned advocates. Stop. Writ petition stands dismissed for default. Parties to act on the server copy. Next.
Item number 4.
Again, on behalf of the petitioner, my lord.
Yes.
So this is the second round of litigation where the petitioner is praying for his higher scale of pay on enhancement of his educational qualification. Now, my lord, he has enhanced his qualification by taking due permission from the DI of the schools. My lord, I have annexed the entire writ petition which was in the first round.
You are challenging order of the DI.
My lord, challenging the order of the DI.
December 2022.
Yes, my lord. That is
Order of the Commission of School Education.
21st of December.
Order of the Commission of School Education dated 21st December 2022.
Yes, my lord.
Where the prayer, your prayer was turned down.
Yes, my lord. It has been turned down. My lord, I am
Show
challenging.
me your approval of appointment.
Yes, my lord. 36, my lord. If my kindly sees.
You are appointed as a past graduate teacher.
No, I
Where
have
is the scope? What no?
my lord,
Come
kindly
to
see
page
page 40.
36.
Kindly comes to page 40, my lord. I have enhanced my qualification.
Maybe.
Joined
But
as a
if
past
you are appointed as a past graduate teacher, you have no right.
in terms of the Utkal Kanti Karan.
My lord, Lordship, I had relied on the
The past
decision.
graduate teacher has no right to claim on postgraduate qualification.
But I have enhanced my qualification.
You
Lordship.
may have enhanced. You may have obtained postdoctoral.
Yes, my lord.
But that will not inure to the benefit of getting higher scale of pay. Are you aware of section 14 of the Control of Expenditure
No.
Act?
Lordship,
Are you aware of the of section
my lord,
14
may I
of
say
Control
one
of
thing?
Expenditure?
My lord,
Please answer
But
yes
this
or
act
no.
has come later on, but I have
Please
enhanced.
answer yes or no. When you have enhanced qualification.
Yes, kindly sees this, my lord.
When you have enhanced qualification.
In the year 2000.
In the year
2000.
Very well.
And
So
the act came later on.
So ROPA 1998 shall come into shall be applied. So let us consider ROPA 1998.
Yes, my lord. That was by law specifically. May I submit, my
Come
lord?
to clause 12.3.
Yes, lordship. May I say one thing, my lord? Lordship, it was a specific
Please come
case.
to very well. I am accepting your contention.
Lordship, kindly listen to
that
my lord for only one
is not
moment, my lord.
required. Please hear this quote first. Your contention is this, that Control of Expenditure Act 2005 is not applicable in your case since you obtained qualification in 2000.
That is one part. And my lord, I had also relied upon Rubikanto Bodmon's case, my lord. Lordship is referring to clause 12.3.
Yes.
Yes, but that is at page 54.
Please read it.
Yes. All teachers, including physical education teachers and librarians of secondary schools who have improved will improve their qualification or who were appointed with higher qualification in the subjects or group relevant to their teaching appointment shall get higher scale of pay appropriate to their qualifications with effect from 1st January 1996 or the date of improving qualification, whichever is later, provided that such higher qualified teachers in the relevant subjects or group
is justified as per approved staff pattern of the.
Yes.
If such teacher, now my lord, after this.
Staff pattern,
Yes.
if it is justified under the
Justified.
approved staff pattern.
Yes.
Are you aware of the system of
Yes,
following staff pattern?
The staff pattern, it has also been forwarded. Kindly see, my lord, I'm coming.
Are you
there.
aware of why you are appointed against a post which was meant for postgraduate teachers? You are recommended by the commission.
Certainly, my lord.
So why you have applied? Because you are not having the qualification at the relevant point of time. After joining, you obtain qualification, or
after-
before when you obtain qualification?
It is,
Must be
it
because
must
you are
be
appointed
after
in-
joining.
You are appointed in
1992, 1993.
So
that
you are not recommended by the commission.
At that
You are
point of time-
appointed in 1992 prior to West Bengal Central School Service Commission came into effect in 1997. So therefore, 1992 appointee cannot be appointed on the recommendation of the commission. Now, you obtained higher qualification subsequently.
With the permission of
Subsequently,
the
you
DI.
obtained higher qualification. Now,
Well, with
now-
due permission.
Propa 2012-3 shall come into play. In your case, 12-3 says subject or group is justified as per approved staff pattern of the school. Now, in approved staff pattern, you will find what is the system of
Well,
staff pattern.
who have improved subsequently. Kindly, my lord.
Subject or group is justified as per approved staff pattern.
But I have been made to work. I have been working over
Staff
there.
pattern in the school means, suppose in a school there are 4 teachers. You are teacher of which group?
Bengali language.
Language. In language group there are 4 teachers for 4 posts. You will find that the 50% of the posts are earmarked for honors graduate, postgraduate teachers, and 50% are meant for past graduate teachers.
Correct.
So if you are appointed against a post meant for past graduate teachers, that cannot be upgraded to postgraduate teachers.
My lord, may I come back, my lord? May I come back on this?
270.
No. Let me just, my lord, with the latest decision, your lordships is also aware.
Yes, special bench judgment
Yes,
will
sir.
have-
That's what I'm saying.
Let me come back, my lord. Let me
come.
my lord, let me go through the judgment once again. What has fallen from your lordships?
Enhancement
May
of
I
pay on acquisition of higher
may I come
qualification
back on this?
during the service career is dependent upon the relevant rules operating at the time of acquisition of higher qualification and cannot be claimed
Which
as a matter
paragraph?
of right. Paragraph 272, my lord. And in mid and two, I think
My lord, but the
or
penalty
something to. It has
my
been
lord, but
held
the
by
last
that.
paragraph has also held that whatever law was prevailing at that point of time, my lord, it will prevail.
But past graduate entry, it has been decided that it's some kind of backdoor entry.
No, that is Mr. Bosumullik in case where a candidate having postgraduate degree is applied under postgraduate category.
Yes. Here, Miller, he has.
Here, it is not a case of suppression.
No suppression.
There are cases where
Yes,
a
Miller.
candidate having postgraduate, honors graduate qualification or postgraduate qualification applied in the RLST as postgraduate.
Postgraduate.
Then it's a backdoor entry.
But that is
After
not
being
my
appointed,
case.
it is not a case.
No.
That is not
No,
my
here,
case.
That is what court is also telling.
My lord. My lord, kindly grants me, my lord,
Sorry.
some time, my lord, I'll come back, my lord. My lord, I cannot, my lord, run away from the court, my lord. May I just come back, my lord? May I just come back, my lord, kindly?
That details are not going. বউ কিনে দিয়েছিল। এটা নাই, এখানে আছে। এই তো 272
Now, special bench has said in paragraph 272, subparagraph A, that a teacher joined the school with a postgraduate degree, and during his service career, the teacher enhanced his qualification and claimed higher scale of pay on the basis of said degree. The said claim has to be decided on the basis of relevant rules
That is what it is saying.
existing at the
At that
time of
point
his acquiring
of higher
qualification.
That
Show
is
me
in
any
2000
relevant rules.
That is in 2000. Now, my
Yes.
lord, now, my lord, my
Show me any relevant rules.
yes, my lord, then Robikanto Bormon follows because Lordship,
Statutory rules. It's a special bench judgment.
Lordship, what I am saying,
Robikanto Bormon will not stand in the will
but
not
it is not in conflict.
Will not come in your favor.
I am extremely grateful, my lord. I was trying to impress upon your lordships to show this particular point because the entire judgment which is there.
Show me the rules.
My lord, I will kindly, my lord, the only rules which, according to the little knowledge which I have got, but the only thing is this: what can help me here is Robikanto Bormon, because my lord, in Robikanto Bormon it was specifically laid down, showing that the ROPA rules would be there.
Yes,
would be there, but that is the only thing.
There
my
is
lord.
no conflict. ROPA rules
Now,
will
my lord,
apply.
what I am saying,
Now,
my lord,
what is ROPA rule? That is 12.3.
12.3.
Now, 12.3 says subject to
now, my lord,
staff
12.3
pattern.
says, now, lordships, may I say, my lord, 12.3, and my lord, there is no conflict with Robikanto Bormon and the special bench's decision, my lord. This I must.
Special bench decision will prevail over Robikanto Bormon's decision.
No, but special bench has itself specifically carved out a provision. It has carved out a provision itself, my lord. My lord, that is what, my lord, the particular sentences, the meaning of their lordships was there. That whatever was prevailing, so that will be there. So it becomes very clear that that 2005 Act will not apply. Because in 2000, the moment I gained that, at that point of time, there was.
You show me that you are entitled under the rules.
Very well, my lord. I shall come back. I shall come back, my lord, with that. No, lordship may kindly grants me, my lord, one opportunity.
No,
lordship.
It is pending for a long period.
I know, my lord, but kindly grants me, my lord, one opportunity, my lord. At the very beginning, your lordships was of the view.
Commissioner has said.
Commissioner has relied on the division bench, my lord.
No, as also on the 2005.
That is of 2014's one judgment, my lord, division bench. In the middle portion, lordship, 1998, it was noticed that 12 February 90 with effect from ROPA was given retrospectively 1st January 96 as per recommendation. Thereafter, my lord, 12.3 has been discussed. Ultimately, my lord, the division bench held that therefore, in view of the observation.
My lord, what my learned friend is reading is Robikanto Bormon. Yes, it
Now-
is Robikanto Bormon.
Now, my lord,
Kindly
yes.
to page 85. It is your lordship's earlier order, where your lordship specifically
quoted in
stated that
his- in his-
31st January 2014, Robikanta Bormon, the last paragraph. What my learned friend is saying, any other division bench, it is Robikanta Bormon and
At
nothing
that
else.
point of time, when this order was passed, my lord, this larger bench was not there.
Not there.
Not
Yeah, therefore, my lord, but when it is not in conflict, my lord, I
and
say
larger
this,
bench, my lord, indicated, my lord, the government should come up with a scheme for incentives.
my lord, larger bench's decision is not affecting me.
What Robikanta Bormon has said.
Yes,
Justice
my lord, that,
what is
my
that
lord,
decision?
that is why, my lord, today I am really handicapped, my lord, on that score. Really handicapped because I'm not having that judgment, but I had shown it to you before your lordship on the earlier occasion. And after noting that, kindly see what your lordship was pleased to hold. And in Robikanta Bormon, my lord, kindly sees. Your lordship has been pleased to hold in the first round of litigation, starting from page 83. I'm reading out my lord, internal page 2. That is page 84 of the writ petition, the third paragraph. The state respondents are represented by Mr. Das, learned advocate, who has defended the decision of the respondent number 4, whereby the prayer of the petitioner for sanction of postgraduate scale of pay has been refused. This court has heard the learned advocates representing the parties and perused the memo dated 27th November 2018 of the respondent number 4, whereby the claim of the petitioner for sanction of postgraduate scale of pay has been rejected. It appears from the said memo dated 27th November 2018 that the respondent number 4, while refusing to extend the benefit of postgraduate scale of pay in favor of the petitioner, failed to assign cogent reasons, accepting the government order dated 27th November 2007, which was referred to in the said decision of the respondent number 4. Now, lordships, at first blush, it appears that the decision of the respondent number 5 is cryptic and devoid of any reasons. In above conspectus, the decision of respondent number 4, as contained in memo dated 27th November 2018, stands set aside. This court directs the Commissioner of School Education, being the respondent number 3, to take decision on entitlement of the petitioner to receive the benefit of postgraduate scale of pay on acquiring higher qualification by him within a period of 12 weeks from the date of communication of this order. The respondent number 3 is further directed to pass a rescind order and the same to be communicated to the petitioner within 1 week thereafter. Petitioner shall be given an opportunity to hearing, and during the course of hearing, petitioner shall have liberty to rely upon the relevant government orders, including the decision of the
Now,
Honorable
this Robikanta
Division.
Bormon judgment was considered by the Commissioner of School Education.
But what he has considered, my lord, I have taken a specific plea in my writ petition that he has not appreciated it in its correct perspective. But he has again gone back to the 2005 part. In Robikanta Bormon, my lord, today I am really handicapped. So I'll place the Robikanta Bormon's judgment once again before your lordship.
That judgment, at least before me, is not required to be placed.
No, who appeared. Therefore, your lordships is also aware that your lordships had specifically before the division bench, and it was a reference. Many learned advocates, those who are appearing before your lordship, they perhaps forget to bring, and they forget of being oblivious to the fact that it was a reference, my lord. It was not a very ordinary case. It was a reference, and it was specifically held that if I come within ROPA, I am through. No other rule, no other order. Therefore, my lord, I say this Robikanta Bormon, my lord, holds good in my place so far as the special bench's decision is not affecting me. It is not in conflict. Your lordships, while appearing, had set the law.
You obtained qualification in 2001.
2000 part 1,
Recorded.
2001 part 2.
Recorded 2001.
Yes, that is the part 2.
What I am telling you that you will find a same thing from come to page 88. Page 88. First, second, third paragraph. Read it. It is true that the managing committee in
Resolution dated 21/6/2006 held that Sri Pradhan was not entitled for postgraduate scale of pay for his MA degree in December 2001, as already 6 assistant teachers in language group were drawing honors postgraduate scale of pay. In it is fact that staff pattern. Now, my lord, I say this.
it is fact that as per staff pattern of the school,
in the material time of the year 2001, there were total
11 assistant teachers in the language group.
6 were already drawing honors postgraduate scale of pay. So as per the staff pattern of the school in the material point in time, in terms of GO number such and such, dated 13/7/1919, read with GO number such as if Pradhan not entitled for postgraduate scale of pay for his MA degree with effect from 02/12/2001. That is
very well.
the
It
last
will
date
be
of
decided on exchange of evidence. Yes. That is what I am telling you. That is apparent from the submission made by the on behalf of the manager. There are 11 teachers.
Yes, madam.
6 were getting it.
And in the last paragraph, it has been held by the commissioner that more than 50%.
Affidavit of service. File your affidavit of service.
Yes, my lord.
Well, I am admitting your writ petition. Let it be decided on exchange of evidence. Yes. File your affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. In the writ petition, order of the Commissioner of School Education dated 21st December 2022 has been questioned, whereby prayer of the petitioner for sanction of postgraduate scale of pay was rejected. Next paragraph. On perusal of the order, next paragraph. State respondents are represented by learned advocate who has submitted that apparently there is no flaw in the order of the Commissioner of School Education dated 21st December 2022. Next paragraph. Having perused the decision of the Commissioner of School Education dated 21st December 2022, court finds that validity of the said decision of the Commissioner of School Education needs to be decided on exchange of affidavits. Next paragraph. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks after ensuing puja vacation. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next paragraph. All parties are present today. Now, school is party. School is party. Yes, yes. Next paragraph. Learned advocate for the petitioner is directed to communicate this order to the non-appearing respondents by 7 days from date and file further affidavit of service on the next date. Get fresh. Next.
Item number 423.
For the petitioner in this matter, but this may affidavit of service.
I am appearing on behalf of Preparation 11 and 12 on behalf of Kaveri Ghosh, my lord. She has not come to the court for personal difficulties, my lord. But I am praying for accommodation on this team.
Opposing this, only the point is that since 2021, one of the selected headmaster of the SAS RN High School in Belma, like the previous headmaster, the master and the president has not given the charge. He has not handed over the charge. All the confidential documents, including the pension papers, service book, everything is lying with him.
Previous?
She will kindly see
The ex-headmaster
and the ex-president. My grievance is against 11 and 12.
So why no liability certificate was issued in favor of the
that was
retired headmaster?
Yes, that was issued by president. That was
president
both are in collusion.
and in lordship lot of admissions and prayers made before the GI,
But how today there is severance of relations, employee-employee relations. Now, how the headmaster can be tackled
Well, the documents are lying with him. Well, I have it's
Because there is employer-employee relationship has
it
been severed.
can be tackled. Well, subject to
How it
correction.
can be
We are
tackled?
lordship. Well, what I have seen is that
He has obtained pension, everything.
the pension
Now no
benefit
proceedings
can
can
be
be
well,
initiated.
whether
Now
it
it
can be
how
stopped.
it can be tackled?
And well,
You
this-
initiate a criminal proceeding against the headmaster for not for unnecessarily or illegally
that is
possessing relevant records of the school.
well,
But today, in this writ petition, no mandamus can be issued
against the
upon the concerned respondent authorities for taking steps against the headmaster, who is a retired headmaster.
only one lordship will kindly consider, my lord. And if today, my lord, his pensionary benefits can be, my lord, anyways, my lord, it can be stopped, my lord.
There is no such provision.
My lord, what I was, my lord, I can come with that decision, my
You
lord.
cannot invite this court to pass an illegal order which is not tenable under the law.
In that case, my lord, let DI take steps, my lord. Let DI take steps in that.
How DI? What steps DI will take? You satisfy me?
My lord,
When the headmaster retired,
21, my lord, March 2021.
nothing remains.
My lord, today, my lord, I have at least made, my lord, a bunch of representations.
Maybe, but today headmaster has retired in 2021. Employer-employees relationship has been severed.
Yes.
Now, no step. How you can tackle the situation?
The only point
You file a criminal proceeding against him.
in that case, my lord,
Have a full-fledged trial before the criminal court and prove it, and then get an order.
documents are with
If he is convicted, automatically pension will be stopped.
and only one point, my lord, if your lordship, my lord.
What one point?
What I'm trying to show before your lordship is that, my lord. My lord, today, my lord, it was not neither fault of any parties. Well, it is
But
something-
no steps, no relief can be granted in this writ jurisdiction.
Very well. Well, lordship will so next week when I'll come back.
No, why?
With the instruction. Well, I'll come.
What instruction? You tell me, because it's a completely a point of law. It does not depend upon your instruction.
fallen off your-
Because headmaster has retired in 2021. 2021 headmaster retired. Now you are the headmaster of the school or managing committee. Who are you?
I'm the headmaster of
Or the guardians?
No, headmaster.
Headmaster. So you are the headmaster of the present headmaster of the school. Now the person who has retired from the post of headmaster in 2021 and obtained all benefits, now there is a employer-employee relationship has been severed. So today no steps have been taken.
Only one thing,
Can
my
be
lord,
taken
lordship
against
will kindly come
that
back.
headmaster.
Well,
Only option which is left open to you is
file a
to
criminal
initiate a criminal proceeding against him by lodging a complaint before the police authority.
Because lordship kindly takes the representation at page 41. My lord,
What representation? What I will direct upon the DI to take decision?
DI, my lord, was sitting tight since for last 3 years to 4 years. Now, my lord, if my lord, today, my lord, if lordship will kindly see in a bigger picture, my lord.
Yes, sir.
All the
Affidavit
documents.
of service filed on behalf of the petitioner is taken on record. Stop. Petitioner is the headmaster of a government aided school who has made allegations.
Now we are the president, man. Petitioner now is the president.
Who is petitioner number 1?
Well, petitioner is the school and petitioner number 2 is the president.
Petitioner number 2 karo. Petitioner number 2 is the president of the managing committee of a government aided school who has made allegation against the private respondents that those respondents have kept certain documents, certain important documents of the school with them. As a result, whereof administration of the school is facing impediments in running the school. Stop. However, from the submissions made on behalf, from the submissions made by the learned advocate representing the petitioner, it appears that respondent number 1 was erstwhile president of the managing committee of the school, and respondent number 12 is the retired headmaster of the school who superannuated in 2021.
The respondent number 11.
Respondent number 11 is the president.
President and 12 is the.
Yes, respondent 12. Yes. Respondent 12 বললাম তো নাকি? 2021. Stop. Therefore, it appears that employer-employee relationship, so far respondent number 12 is concerned, was severed in 2021 due to superannuation. Therefore, today, based on the allegations leveled against respondent number 12, a mandamus cannot be issued in order to protect the interest of the school. Stop. Furthermore, respondent number 11 was erstwhile president of the managing committee of the school, who is no way connected with the administration of the school at present. Stop. Therefore, representation which has been which has been made before the concerned respondent authorities, making allegations against respondent number 11 and respondent numbers 11 and 12 cannot be delved into at this belated stage by the authorities. Stop. Next paragraph. If petitioner is aggrieved by the acts and actions of respondent numbers 11 and 12, leave is granted to them to take steps in accordance with law by bringing the issue before the concerned authority in accordance with law. Stop. Stop. On this writ petition, no relief can be granted to the petitioner. Hence, the writ petition stands dismissed. Urgent introduction.
Only one records one thing. Page 33 and 34.
Next.
If specific thing has been recorded in respect
Yes,
to
yes.
that, all
To initiate criminal proceedings. Yes, next.
Item number 424.
Conversion of
GPF to GPH, the interest part.
interest. At the time of call, learned advocate representing the petitioner court. Learned advocate representing the petitioner submits that on similar issue, other matters are pending before the on similar issue, matters are pending before the Honorable Division Bench. Next paragraph. Hearing of this matter stands adjourned. List the matter under the same heading in the monthly combined list of November 2025. Next.
Item number 426.
Service has not done, Lordship.
Yes.
Service has not completed, Lordship. I am paying for 2 weeks
For
evaluation, Lordship.
18 March 2024 filing service is not completed. Then there is nothing in your writ petition.
Lordship, kindly direction may be given, Lordship. 2 weeks accommodation, Lordship. I am
No,
paying.
why you have not served? It was filed on 18 March 2024. Why it has not been served? Notice has not been effective.
Lordship, kindly allow 2 weeks time, Lordship.
Nothing remains. It relates to first state level selection test 2016. This has been set aside by the Honorable Supreme Court. And now you are praying to disclose breakup of and segregation of marks obtained by the candidates. In written examination, academic, professional and personality test in respect of first SLA, first state level selection test 2016 classes 11 and 12. Issue. Learned advocate representing the petitioner submits. Learned advocate representing the petitioner submits that by presenting this writ petition, challenge was thrown to the selection process, namely first state level selection test 2016 for classes 9 and 10. Stop. Next paragraph. Matter has become infructuous in view of the judgment delivered by the Honorable Supreme Court dated 3rd April 2024 on a civil appeal arising out of special leave to appeal within bracket civil 9 civil appeal arising out of special leave petition within bracket civil number 9586 of 2024 within bracket State of West Bengal versus Boishaki Bhattacharya Chatterjee and others, wherein enters selection process, that is first SLST 2016 for classes 9, 10 and 11 and 12 has been set aside. Stop. Next paragraph. Hence, the writ petition stands dismissed as infructuous. However, there shall be no orders to cost or urgent xerox, etc. Next.
Item number 427.
For the petitioner. Kindly come to the status.
Transfer.
Yes. Page number 79. The last application was on medical ground.
Yes.
Single subject teacher, but on medical ground. But when it was not considered, I moved a previous writ application.
Single subject teacher, but medical ground.
A previous writ application was moved. An order was passed by the coordinate bench.
Transfer application.
থেকে চ্যালেঞ্জ করে দেয়।
Yes.
Well, they have challenged page 84, my lord.
I'm coming.
The decision of the school authority. So, my lord, school authority representation of the school authority is required.
Round of litigation, page 81. Order of the Honorable Coordinate Bench. Since no step was taken, page 81 is the previous order.
The school authority has to be heard.
Yes.
81 in Lordship has taken the previous.
Page 84.
Page 81.
Written order by the headmaster.
Yes, page 81 was the previous order of the Honorable.
Where is the service upon the school authority? When?
It is the difficulty of 2024 matters. Again,
Old service.
No, new service is there. Like 2024.
2024.
One and another one is on there is no other affidavit of service in the record. This 2024.
So this written order is under challenge.
This written order is under challenge.
Now, how headmaster can take a decision in case of a single teacher in the subject? The steps are required to be taken by the
District Inspector of Schools.
But only problem is, since this order is under challenge,
Understand.
needs to be serve a notice conveyance. Though you have subsequently served in the month of July 2024, indicating that matter is to be moved before this.
Twice, two affidavit of services are there.
Show me this notice.
Actually,
Twice it was served. First, indicating that matter to be moved before the coordinate bench and subsequently before this bench.
actually, there was no direction upon school to decide. It was upon the DI to decide. Now, school, showing its interest, has issued that order as per the last coordinate bench's order. There was no direction upon the school. School Suomoto voluntarily passed that order. I had to challenge that.
Where is the order dated? Order passed in WPA 12937 of 2022.
81, page 81.
In view of the above subjects, yes, DI to the direction ছিল
Yes.
কন্টেম্প হবে
Order challenge না করলে contempt এ যাবো।
তোর প্রতি কোনো ডিরেকশনই ছিল
Oh, I have to challenge this order. মানে contempt তাই করবে কি করে? ও তো পাঠায়নি আর কি।
Who was this one number 5?
I was DI.
DI.
Now there was a direction upon the school.
সার্ভিস করছে তাকে এটা খাতাটা লেখা ইভেন্ট খাতাটা লেখা ওটা আরো হয় সবসময় আগে
No, direction was upon the respondent number 5. DI.
Yes.
Now, why the school has taken
Yes.
decision?
School has taken this overzealousness and passed this order, reasoned order. That's a reasoned order.
And from
Possibly because it
from
was
that
returned by
order,
the DI.
contempt proceedings.
No, it is standing in my way. Because my lord, it was returned to the
Directly
school
was
authority by the
passed upon
DI.
the DI.
DI had returned it back to the school. Lastly, as per the status. Now, school.
We'll come back tomorrow.
There you.
Take it back. Take it back.